Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
That was getting commentary on the case. Dati mihi Anglican for his verbal Martin.
That's literally not true.
All right, welcome back from lunch. Thank you. Welcome to the Court of Public Opinion. I am the Recovery Addict. Thank you very much for joining me this afternoon. We are returning to the Take Care of Maya trial, as this is part 36. I've been naming each segment, and every time they break for lunch, we break and start a new segment. We've got 36 parts to this trial. It's been a long one. It's a long haul, but there is so much to this trial, so much to it. All right, we have to do a couple updates. First things first, we have to go in order. It's very important we go in order here. So first of all, we have to appropriately recognize Britta Aller for being first in chat. Britta, congratulations. First in chat comes with the prize, penalty, and punishment of internet ownership. So Britta, you have won before. I can tell from your rap sheet. You're a repeat offender, a habitual offender even. Congratulations on being first in chat. Thank you very much for opening the door to this area and letting everyone else just come in. Once the door's opened, everyone can chat. That's how it works. It's just like opening the door in court. Thank you, Britta. I leave the internet in your capable hands. The next question is about the lizard. The lizard is safely outside in the dirt. I think it will survive. But when we say lizard, we're talking. Let me show you guys. Lizard, a tiny, tiny, tiny baby skink. It could not eat a worm. The worm would eat the lizard. It was very small. I think it'll be okay. It was captured and released out in the dirt. That's just how they like to live, and we'll see. We'll see. It's tiny. We have found they do get bigger. They get like about yay big. I'd say that and for those of you who are right now holding up a tape measure to the screen to see how big this is, it's about 8 to 10 inches. That would be my guess. And no jokes there. Anyway, we're going to move on with that. I wanted to talk just a little bit before the jury comes back, because right now where we're at, we're just looking at the door. We just have the door right here. So before the jury comes back, I just want to say the jury has become the story in a large part on this trial, and it's remarkable. We heard some interesting comments, specifically during the jury questions, sort of like I won't call it a sidebar, because it's not really a true sidebar. It's while the lawyers are conversing with the judge about the questions from the juries and from the jurors. And we heard a comment from Mr. Shapiro on the defense team, where he indicated that there was a clear impression in his mind, at least, that one or two of the jurors might be considered hostile jurors. I Googled that. I don't find that in the lexicon. It doesn't appear to be in the regular legal vernacular for trial. You don't hear about a hostile jury. You hear about a hostile witness. And a hostile witness is one that really doesn't want to play by the rules, that doesn't want to answer the questions. And in the case of a hostile witness, you might have the judge encourage them to follow the rules and answer. They can be led with questions that are just yes or no, because you can say those through gritted teeth, which is usually what you get in a hostile witness scenario. But hostile jury? I've heard of a runaway jury. There's a great movie by a book by John Grisham, and I'm not insinuating anything here, but that movie's all about a jury, and I believe if I remember correctly, which I usually don't, it's about a jury that gets bribed to go one way or the other, and it's a big lawsuit. In that movie, I think it was an astronomical amount that was involved. I think it was 110 million. Yeah. So that's not the same as this is a 220 million case, which is different. But yeah, in that case, they had a jury that could literally be bought. That's my recollection anyway. Nobody's insinuating that here. Nobody at all. Nobody on the defense, nobody on the prosecution, the judge. There's no indication that there's anything wrong here. But maybe if you mix the two, you might have a runaway verdict. A runaway verdict, that's a thing in the legal world. It's terrifying, especially if you're the side that the verdict is coming down against. Especially, that's when think about a runaway truck, right? The truck has lost its brakes. It's going where it's going, and there's no stopping it. And it will go as far as it can, and you'll need a mountain to slow the thing down. Imagine a jury, all united, headed one direction. And going to go as far as they can go in that direction until they're stopped. That would be a runaway jury. There's a runaway bride too. Yes, that's very different. But thank you, Krista, for that. The last thing, Alley Cat, you are so right. The defense is petrified of this jury. It's awful. I think they're losing sleep, and have been for weeks. The last thing I want to mention and remind you, this is a civil case. So although, and Jules, she might be able to call in, I'm not sure, she might be on break, but
jurors are the finders of facts.
They
can ask whatever they need to make their decision. What Shapiro finds hostile is the jury leaning against Jack.
Yes. Casey Cat, thank you. The jurors are asking questions. And I talked this over with Mrs. R.A. over lunch. I was eating a delicious slice of her yummy bread that she made yesterday, and then I helped myself to her pumpkin chocolate chip cookies. And now I can tell you why the diet's not working. It's really good food. Anyway, we were talking about this, and we're saying, what's the possibility that these jurors aren't as court familiar as we might think? That's like a hyphenated word, court familiar. When they started out, their questions were not like this. They were not so, they were not structured in this way. They didn't have this tone, this voice. What if we just have jurors who are really good at learning and observing? And when they started out and started asking questions and they were getting feedback like, jurors, I'm not going to be able to answer those questions and ask those questions. They're like, crap, I must have done something wrong. Well, what's a good example of a question we can ask? Well, Mr. Anderson's asked a couple that have been allowed. So what if we ask questions the way Mr. Anderson asks the questions, and then we can get them in? I don't know. I think they actually do have quite a bit of legal experience, or some of them have legal experience, but I think others might be mimicking what they hear, and also a little bit, maybe indicating
I don't think there's anything wrong with the jury. I just think we're not used to seeing just questions, so it looks different to us. They are curious and skeptical just like the rest of us.
Aaron, great answer. I honestly don't think anything is wrong as well. The judge has indicated he doesn't think there's a hostile jury problem. Although, just like, there's a hostile plaintiff attorney, right? You've got Mr. Anderson who's asking questions that could be like bullying the witness a little bit, could be quite adversarial in form. The jury's doing basically the same thing. So I'm not saying there's anything wrong with the jury. Now, speaking of the jury, though, we do want to talk just a little bit about them, because this jury in Florida, in a civil case, it's not like a criminal trial where you need 12 jurors and a unanimous decision. We do have 12. I think we've got 12 jurors in. Why am I thinking 13? But 12 jurors, and in there listening to evidence, but only 6 of them will deliberate. You only need 6 to deliberate. That's this many. I counted on my fingers. To deliberate, and to win a verdict, you only need 4. So when it comes down to it, 4 of these jurors will decide the verdict in this trial. That must scare the defense to death. Really, it must be crazy. Pickles the cat, I see you here saying, is there a podcast tonight? Yes, we are doing a podcast tonight. It should be at 8 p.m. on this channel. I realize it conflicts with Rob, so as soon as the podcast is over, I might jump over there and follow his recap. But Weather Watch and I do a podcast every Friday night. Weather Watch is one of our great mods, good friend of mine down in Texas. Just a phenomenal person, all in all, good friend. And we do a sort of like a decompression type podcast where we look at some of the lighter stuff, as we've usually been following some pretty heavy topics all week long. Sometimes as we get into the weekend, it's nice to just take a deep breath and relax a little bit before the weekend. So that will be going on tonight. Thank you very much for the reminder. Valerie Ivy says, Recovery Addict, if the jury has sounded like Mr. Alderson, though, I do think the defense has an argument towards bias. So, Valerie, the bias is an issue. If you have a juror that concealed a bias and did so in an effort to get on and sway the jury, there you have a problem. But you also have a problem because you have to be able to prove it. And I'm not sure if these questions alone, even if they are leaning one direction or another, are enough to prove that this juror did this. Obviously, after the fact, if a juror talks and spills the beans, that might open the floodgates, and suddenly we see appeals all over the place. My dog Clover, I agree with Rob on this. There will be an appeal. There will be an appeal. This, when the judge brings down the gavel at the end of this trial, it is not the end. That it's the end of this chapter, and there's probably many more chapters in this book that'll go on, and the actual number will probably change. If there's a verdict with damages attached to it, I'm almost guaranteeing that number will change. It won't stay the same. All right. Anything else we need to cover before we go back to court? Let's see here. Here we go. Let me go down there. Okay, we're talking about super source on. Downstream keyer on. Let's see where we are in the objections. Just for those that don't know, we did a little contest earlier.
Here's a chuckle. My daughter's HS was closed today. Apparently, the utility problem was a deer. Either it got in the school or chewed wires or both.
Deer chewed the wires. I've heard of squirrel chewing the wires, but school's out because of reindeer. You know, Rudolph was getting frisky with the wires. I guess I don't know. Row, that's sort of funny. A little day off. Thank you for that. Okay, we've got in the names we see on the screen above my picture. We had about 1,000 entries in the contest. We just wanted to see, because this case has so many objections. We said, "What's your guess? Just total objections. How many were you going to hear?" And I realized how many we hear is different from how many they actually are. You could probably go back through the actual record and count these up. We're not doing it. It's not going to be that official. But every time we hear an objection, I'm going to count it, and it's right now we've counted 1,188. We have about 1,000 entries right now, and right now, let's see, we've got to scroll down a little bit. Selena, Dusty Den, Nate, LNG, Stephanie Poston. Right now, you are right on the money. You're right on the money with your guess. Coming up next, we have Ugly Betty, Fine Citizen, Carolina 5-0, a few others, but I think we're probably going to pass those. So Stephanie will keep you right there. We'll turn this off so it doesn't distract during the court case.
Love y'all, Ty, for allowing different opinions chat.
Hey, the different opinions, Ivan, thank you very much. We love different opinions. We especially love them to be shared in a respectful way. And Ivan, thank you for doing that. I will never try to tell you that I have the absolute truth on everything. That I know what that what I think is how everything is. I oftentimes I'm corrected and informed by you guys about actual situation, the truth of the matter asserted, and it helps me to help form my opinions by listening to people who have other opinions. So thank you for doing that. Perry Mason says, I don't think we can assume so much about what the jury is thinking. Questions could reflect
Let us know you're here.
Of one
Hit the like button, thumbs up with light skin tone check mark.
Cachette, thank you very much. I appreciate you asking people to hit the like button. The like button does help the channel quite a bit. It helps YouTube, in its infinite wisdom, determine who else out there should probably hear about the channel and probably would feel comfortable and like being here with us. So if you want a few more friends in here, because it's always fun with a few more friends, let me know. How much longer will this trial last, please, says Angelica with a J. I think that what we heard this morning, as the judge sort of expects, they would like the jury to be done deliberating before November 9th. So we're right now we're sitting at October 20th. That gives us 11 days here in October and 9 days in December, but some of those are weekends and Saturdays and Sundays.
Okay, please be seated, everybody.
We're already back. All right, we're kicking it off. Rudy Patootie, thanks for gifting a membership. Appreciate that.
Everyone's back from lunch, and
hey, Judge.
I heard there was a proffer in our works.
Yes, before.
I've got a Lindsay Masika
on Zoom.
And Cheryl Westmoreland on Zoom right this second.
The attorney is, that's her, that's the CF attorney. Lindsay Masika is the witness.
Do I need to put them in the waiting room first, or?
Well, we can do the proffer real quick, but then before we actually do her testimony, we wanted to play a snippet of Mr. Kowalski's deposition.
Are we doing a proffer now? And do I need Lindsay Masika here, or do I need to put her in the?
Well, we can do the proffer, Judge.
Okay. Lindsay Masika and Attorney Westmoreland, if you could.
So Maya's clearly back in the courtroom. I wish we got more courtroom views than just focusing on Maya.
Attorney Westmoreland, let's turn on your Zoom. Thank you.
Your Honor, my name is actually Deanne Fields. I'm an attorney with DCF. Miss Westmoreland is under the weather today, so I'm subbing in for her.
Ooh.
Yeah, can you tell me your name again?
Deanne, D-E-A-N-N-E, Fields, F-I-E-L-D-S.
And
I'm also an attorney for DCF.
And Miss Fields, is Deanne, is the A capital or is it just lowercase a?
It's just lowercase a.
And did I do that properly? If you look, did I get it properly?
That's correct.
Okay.
That was impressive. Changed her name.
Just so the transcript's clear, this is a proffer. Miss Masika, are you currently in the state of Florida?
Yes, sir.
Please raise your right hand to be sworn as a witness. Do you solemnly swear or affirm the testimony you give is the truth?
I do.
Thank you. Please lower your hand. Miss, or who's starting the proffer?
Can I just explain to Ms. Masika, because I didn't,
sure.
About what they're... So, Ms. Masika, the jury is not in the room, but we're just going to do a proffer of what your testimony is going to be. And then when the jury comes in, I'm going to have to ask you the same questions again. Okay?
Okay.
All right. Okay, so I'm going to skip background. But Ms. Masika, back in October of 2016, you were working as a CPI supervisor, correct?
Correct.
All right. And you had some involvement in the Kowalski matter, correct?
Correct.
Okay. Was it the situation, or do you recall the situation where Maya Kowalski was sheltered at Johns Hopkins All Children's Hospital at that time?
I do.
At the time, since Maya Kowalski was sheltered, was it required that any visitors, before they could visit Maya, have a background check run by DCF?
That is correct.
Okay. In addition to being involved in background checks, do you also recall a situation where Mr. Kowalski was visiting Maya in October, get the date here, October 24th of 2016, and you were requested to advise on what items could or could not be brought into the room?
I do.
Okay. And was that in your role as a supervisor for DCF?
Yes.
And did you specifically not allow in the razors?
That is correct.
And did you specifically not allow in the communion?
That is correct.
And was it your comment to, was it your concern with regard to the communion and your comment, therefore, that there was a concern there could be liquid ketamine on the communion?
That is correct.
At one point in time, was there an attempt or interest in transferring Maya to a medical foster home?
There was.
Okay. Can you explain what a medical foster home is?
Yes, that is a placement for a child to go where there is higher level of training in the medical field to be placed after a child is taken out of custody of their parents.
Okay. And Is it your understanding, for whatever reason, that did not occur?
Yeah, that did not occur.
All right. That would be it, Judge.
Any questions from the plaintiffs?
Just very briefly, extremely briefly. Ms. Masika, my name is Nick Whitney. I represent the Kowalski family. I have a couple of emails of yours from October 24th and November 29th, 2016. Do you have emails with you this afternoon?
I had some things forwarded over to me, but not everything from the case prior of the deposition.
So let me ask you just specifically about these emails. I have an email from October 24th, 2016 from yourself to Cynthia Zangari, CC, and Kathy Beatty. Do you have access to Do you have access to that email as you sit there today?
No, I do not.
And secondly, I have an email here from yourself to Kathy Beatty from November 29th, 2016 at 10:59 p.m. Do you have access to that email as you sit there today?
No, I do not.
Thank you. Thank you.
You're welcome.
Okay, Ms. Masika, what I'm going to do is I'm going to place you into the waiting room. I'm going to let Attorney Fields remain, but I'm going to put you out of our presence, okay?
Okay.
The transcript should reflect that.
This is the Zoom view I have.
Ms. Masika is out of our presence.
So, Your Honor, I have two issues. First is my questions are directed at I want to refresh the witness's recollection, but without access to her emails, I'm left not able to do so. So on that basis, we'd like to either give some time to get these emails over to her or postpone her testimony to another day.
Well, Judge, I'm sorry.
Go ahead.
Well, can I hear the...
And then secondly, I don't have a problem with the questions regarding the razors or the communion wafers. I do think the questions about transfer to medical foster care and that not occurring wades into the Chapter 39 issues in this case.
On the second aspect, the medical foster home issue.
Well, the reason I bring that up, Judge, is because the accusation against Ms. Beatty in her deposition was that she wanted to just put Maya in a foster care like it was some negative type thing. So I just wanted her to explain what a medical foster home is. It's not like...
No, that's in Chapter 39. Discussions about medical foster care will be not allowed.
Okay.
Now, were there any other aspects of the proposed testimony?
The substance of the testimony, I don't think is problematic so long as I have an opportunity to refresh a recollection, and that's...
Well,
I thought the witnesses were provided with a document.
Can we do that right now outside the presence of the jury?
Well, and Judge, because I think one of the emails he wants to refresh her memory about is about a situation that the court has already ruled is not admissible. So,
okay. Well, the question of refreshing the recollection is a different question of whether the testimony is relevant. So I'm just asking from a, can we just put up on the screen right now those emails and she can read them outside the presence of the jury?
If only Zoom had a share screen
and then
function.
She'll go first.
Sure.
Nobody.
So do either Mr. Reyes or Mr. Is it Cottrell? Have the ability to put those up, and let me bring in the witness.
You need to enable screen share.
I do, huh?
Can I see what you're going to show her?
Yeah. That would be.
The host is enabling screen sharing right now. The judge is running the Zoom. He doesn't have a...
Try that.
...support doing it.
Judge, I think if we showed the court what he wants to refresh her memory with, we can have an order on it, because I don't think it's appropriate.
Okay, well, bring the pieces of paper up first.
We move our chat out of the way so we can see it properly. There we go. Blue Skies, welcome. Good to have you here. Thanks to everybody who's come over from Lawn Lumber. I can't thank Rob enough. Is Rob in chat? Did I just see that? I know we had a meeting this morning.
And
yes.
Mr.
Rob, you look good in blue.
What is the topic or topics that you seek to go into?
That the source of information for Ms. Masika is...
Mr. Reyes?
Yes, Your Honor.
I'm hearing feedback, and I think you were the most recent one to sign on, so.
I fixed that before I logged in.
Okay.
Do you still hear it?
Right this second, I do not.
Yes.
Mr. Whitney?
Yes, Your Honor. I want to, there's another one in front of you there, Your Honor, behind the screen. Oh. So with 2123, 610, and 611, it's that the source of information for Ms. Masika's interactions with the hospital was Ms. Beatty. That, having refreshed her recollection, Ms. Beatty characterized phone calls as damaging for the child, and that Ms. Beatty suggested to Lindsay Masika that Beata could not discuss pain or pain medications with her daughter, and to point out that the shelter order retained medical decision-making with the parents. That's the basis of my questions to 610, 611.
Okay, on those questions don't go to the issue that I've previously said is the issue that's going to be going to the jury, so I don't see how those questions are relevant.
Which issue, Your Honor? I'm sorry.
As to whether there was a delegation. The fact that Ms. Beatty was talking to DCF is besides the point. That was the process for the Chapter 39. So that's not any problem, and I've been pretty consistent with that. So let's move on to your questions with respect to 2123-032.
Give me a second, guys. I'm going to try to fix audio. There's going to be a little
I
jumps
thought
in the video.
issues with the phone calls were related to the intentional infliction claim.
Tell me the specific question you want to ask.
That Ms. Beatty was listening in on the phone calls and characterizing them to Ms. Masika as damaging for the child.
The question of whether she was listening on the phone call is relevant. The characterization damaging to the child is not.
And so
then I would alter my questioning with respect to that 610.
Perhaps we can ask her in proffer whether she has a recollection of whether Ms. Beatty was listening on the phone calls.
Well, Judge, I think it has to be very careful. This is not the same phone call the jury heard. That was November 15th, 2016. And I don't want this to be confused, and the jury thinks that this is referring to the November 15th call that we've had so much testimony about. This is a November 29th, 2016 call.
So be very specific as to the date, and then in proffer we'll ask her, and if she needs to be refreshed as to whether it was that day or not, then we can show this email. But I don't want the substance of the email being discussed as part of an answer.
I understand.
So let's move on to the other exhibit, which is 2123-032.
Yes, Your Honor. Now, this is an email exchange between Lindsay Masika and Kathy Beatty. And my questions are going to center around...
First off, who is Cynthia Zangari?
Great question.
Zangari.
She was the CPI. One of the CPIs was referenced in Ms. Nihas' testimony earlier.
And you have Ms. Beatty CC'd here on this email. So defense counsel's questions centered around the decision to not allow the razors, but you'll see at the bottom of this email, there's a whole host of things that were being provided.
Oh, I was going to get into what was, I'm sorry if I left that out. I was going to ask her what was provided, what was allowed in, if that's the question.
And so then I was going to ask her a question about who, you can see there in the primary paragraph, who was she deferring to at the hospital to weigh in on these decisions? and she's asking directly Kathy Beatty. So she's seeking input of Kathy Beatty before making any decisions. And then I was going to ask her, based on this, who is Jen? I don't know who Jen is, but there's authorization here from Jen to let the communion wafers in. So I wanted to ask her that question.
Judge, first of all, the email that asked Kathy Beatty is from Cynthia Zangari, not from Lindsay Masika. And then it goes up the chain, and Lindsay Masika is the one, do you have all the email there? Because Lindsay Masika then is the one that says, no, what if they put ketamine on the communion? And she's the one that decides it can't come in.
That did seem like a far-fetched reason to exclude it. It's nice to see them sharing paperwork.
You're trying to imply that Ms. Beatty had some decision-making about this, and this was DCF all the way.
I mean, it says here, Kathy, are these items okay? I want to ask this question if they were deferring to Kathy Beatty.
I think that seems like a fair question. What's the judge think?
That line of questioning I don't think is appropriate, no.
Bummer.
So we'll bring back in Ms. Masika, and you can ask her in proffer about, was it November 29th question, whether Kathy Beatty was on that phone call or whether Kathy Beatty said she was on the phone call or whatever you're going to ask her.
Does that lay the foundation for the next question?
Proffer.
Then for purposes of the proffer, outside of these emails, I'd like to ask a line of questions about other items that were taken away from Maya Kowalski and whether she had any involvement.
That's fine, but, those other issues are not going to go into the jury, but if you want to do that within proffer, that's fine. But let's do it now so we don't have the jury waiting, okay? I'm going to bring Ms. Masika back in.
So when we're going to be able to show her this email?
Well, let's see if she needs it first. Hi, Ms. Masika. This is Judge Carroll again. We're going to have a few more questions. The jury is still not in our presence, okay? Mr. Whitney is going to ask you some questions.
Okay.
Hi again.
Hello.
My first question is, do you recall email correspondence between yourself and Catherine Beatty and others on November 29th, 2016 regarding a phone call between Beata and Maya?
I recall having emails between everyone. I just wouldn't be able to say the specific dates without it in front of me.
Would it refresh your recollection if I showed you that email?
Sure.
Judge, I think the ultimate question was going to be asked as opposed to...
We're in proffer. Let's just put up the email and let's move on. Okay, let's put up the 2123-610.
Yeah, I wasn't saying to put it up in front of the jury.
Suddenly everyone's feeling religious. I think it would be sacrilegious for them.
Ms. Masika, if you would take a moment and review your email back at the top and then Ms. Beatty's email, at least the first part of it below, and let us know when you're done.
Okay.
I was saying thank you to Rob. I didn't know he was here yet, but he's here. Rob, thank you very much. I appreciate you trusting me enough to recommend some of your followers come watch over here. So thank you very much, my friend. Love having you guys here. And we did make him blue so he wouldn't get caught in the slow mode. so thank you. I'm not putting him to work. I'm not going to pay him to be a mod. That's not going to happen.
Okay.
Ms. Masika, was it apparent to you that Ms. Beatty was monitoring the phone calls between Beata and Maya?
Objection.
Okay, you can answer that.
Yes.
Other questions you might have in proffer?
Ms. Masika, there are certain items that you approved and certain others that you disapproved. Those were discussed with Johns Hopkins counsel a moment ago. For example, you disapproved the razors and ultimately the communion wafers. Do you recall approving things like deodorant, body wash, nail polish remover, nail file, earrings, chapstick?
Yes, I do.
as a general rule, did you allow toiletries and items for Maya's care in the hospital in?
Yes.
Was there ever a point where you disallowed shampoo?
Not to my recollection, no.
Was there ever a point where you became involved in disallowing a Tommy Hilfiger Christmas dress?
No, sir.
Was there ever a point you became involved in disallowing chocolate cake?
No, sir.
Was there ever a point you became involved that you disallowed rosary beads for Maya Kowalski?
No, sir.
Did you ever disallow a prayer book for Maya Kowalski?
No.
That ends the proffer.
Anything else, Ms. Quarles?
Not the proffer, just some argument.
Okay, ma'am, I'm going to put you back into the waiting room. We'll call you back in just a couple minutes.
Okay, thank you.
Okay, the transcript should reflect Ms. Masika is out of our presence.
Judge, I'm sorry.
Go ahead.
Judge, despite the court telling counsel that it had to be specific on the time, he's again trying to blur the lines, and he just said, are you aware of Kathy Beatty monitoring the phone calls? It has to be date specific. They're going to try and imply that that's a November 15th call.
No.
I'm confident Mr. Whitney is going to use the specific date when he asks the question.
Well, he didn't on the proffer, that's why.
Well, she had the email in front of her, but I will triple check. I'm circling it. I'm starring it. I will use the date.
Anything else?
No.
Now, on the last bit of questions about the rosary beads and all that, any further statements about?
Well, the point of this testimony from defense counsel's perspective is to shift the blame for items that were kept away from Maya Kowalski to DCF. So we need to be allowed to explore and highlight for the jury that, yes, that may be true of some items, but that's not true for the items that I just went through there with Ms. Masika.
Ms. Gross, that I'm telling you that the questions that Mr. Whitney just asked and that explanation is gaining traction with me. So why shouldn't he, being Mr. Whitney, be able to ask those questions?
I'm not objecting to this, Judge.
Okay, you can ask those questions.
Thank you.
Anything else before we bring the jury in and Ms. Masika?
1 second, Judge.
Your Honor,
You've cleared your other problems too.
I would like to stop sharing, but it appears that that's not even an option for me. I was able to share the document or share my screen, but now I can't unshare it.
Well, I'll tell you what, let me do this.
Your Honor, I'm stuck in Zoom and I can't get out. That would be terrible. He should not be able to. We should not be able to see everything that he does on his computer at all times. They need to sort this out. While the jury's coming back in, I just want to say, yesterday I was speaking with Dr. G from Dr. G Explains. He is going to be making some videos about the Maya trial. He is the clinical psychologist. He's been on the.
Well, I'll tell you what. No, hold on a second. Let me just disable your rights to share.
Thank you.
Judge, before
that fixed it.
I'm sorry.
That fixed it.
Okay, so really we don't
news.
need to show her any documents.
That's correct.
We're trying to line something up next week
Ms.
where we
Ross.
can do this.
Before this witness, we wanted to play a 5-second snippet from Mr. Kowalski's deposition. If it's going to mess up with the setup,
It's going to mess up the setup.
Then we'll just do this, Judge. That's fine.
Yeah, I'm sorry, but
I understand. That's fine.
Don't mess with the tech.
I'm
It's
going to just
working.
bring in Ms. Masika. I'll tell the jury that I've already put her under oath. Okay, let's bring in the jury, please.
Okay, so Dr. G and I are trying to figure out a date next week.
And Ms. Masika, I'm bringing in the jury right now. I'm going to tell them that you are under oath.
Okay.
It may be a lunchtime
So just
stream,
take a moment for the jury to
because
come in.
Court is really, it's booked up. We don't have many breaks. Either it's going to be in the evening or it's going to be lunchtime. But we'll sort something out. He wants to do some stuff where he's just taking a look and giving his feedback on some of the doctor's testimony that we've heard in the trial. So I'm really looking forward to that and grateful for him wanting to do that and being willing to come over on the channel. Now, typically, as we've seen with proffers, initially on the proffer, it's very narrow.
Okay, welcome.
Sometimes we
Everyone,
get
please be
into more
seated.
detail on the direct
So,
testimony here. So let's see.
did you have a good lunch on Friday? I want to confirm while you're away on lunch, you did not discuss this case amongst yourselves. You did no investigation and you received no information. Is that all correct? Correct. And that you did not observe any sort of media accounts about this case. Is that correct? Correct. And that no one approached you about this case. Is that correct? Correct. Okay. Our next witness is going to be by Zoom. I have already administered the oath to her, so she will be testifying under oath. Ms. Crowells, if you could please call your next witness.
Yes, the defense will call Lindsay Masika.
Okay, and you may proceed when ready, Ms. Crowells.
Thank you. Good afternoon. Can you hear me?
Hello. Yes, I can. Can you hear me?
Yes. Would you go ahead and state your name for the record, please?
Yes, it's Lindsay Masika.
I've said your name wrong. I'm so sorry. Masika.
That's okay.
Ms. Masika, what is your current employment?
I am a therapist.
Okay. Prior to being a therapist back in 2016, did you work for DCF as a CPI investigator or CPI supervisor?
Yes, I did.
And what does CPI stand for?
Child Protective Investigator.
Okay. And how long did you work for CPI?
Approximately 6 to 7 years.
Okay. And was that back in 2013 until 2019?
Yes.
Okay. So back in 2016, you were a supervisor for CPI?
Correct.
And that's part of DCF?
Correct.
All right. And at that point in time, did you have some involvement with the Kowalski matter, the Maya Kowalski matter?
I did.
Okay. And with respect to that, you understood back in October of 2016, when you were involved, that Maya Kowalski was sheltered under DCF custody, but remained at Johns Hopkins All-Children's Hospital.
That is correct.
Okay. And as a result of Maya being sheltered, was it required by DCF that any visitors had to have background checks be conducted before they could visit Maya?
That is correct.
Okay. And were you involved in communicating with Mr. Kowalski about that?
Yes.
And did you, in fact, did you do the background check, or was that assigned to someone else?
That could have been a combined effort. Once we get the individuals, we submit the request.
Okay. And the individuals names would have to be submitted to you by Mr. Kowalski, correct?
Correct, yes.
And regardless of their position in life, whether they were a teacher, a priest, a baker, whatever they were, they had to be approved and vetted by DCF before they could see Maya, correct?
Come forward just a second, and I'm going to place my microphone on mute to you, Ms. How do you say your last name again?
Masika.
Ms. Masika. Okay.
Masika, spelled M-A-S-I-C-A. Masika. I think you guys are right. Mr. Anderson said that his daughter is turning like 12 or 13, either yesterday or today, and I think he's gone to celebrate with his family. I mean, I don't blame him. I don't blame him.
Hey, Ms. Masika, I think you need to unmute yourself. Thank you. I'm going to sustain the objection. You don't need to answer that question.
All right, Ms. Masika, do you remember back on October 24th, 2016, around that time, being involved in determining what items could be brought into Maya Kowalski's room by her father?
Yes, I do.
Okay. And specifically, was it you that made the decision that the razors could not be brought in?
That is correct.
Okay. Was it also your determination that the communion could not be brought in?
That is correct.
And was that because of your stated concern by you that there might be liquid ketamine on the communion?
That is correct.
Okay. And that's on behalf of DCF, correct? That you made that statement?
Correct.
All right. Yes. You did allow some item in though, correct?
Yes.
Okay. Let me just ask you, do you recall that you allowed in the body wash
Yes.
The earrings, the nail polish remover, a computer lab workbook, nail file. Yes?
Yes, that's
Sorry.
correct. Yep.
Chapstick and deodorant, correct?
Yes. Yes.
Okay. Thank you, ma'am.
Mr. Whitney is going to have some questions now.
Good afternoon.
Incredibly witty.
Ms. Masika, have you had the opportunity to review an email between yourself and Ms. Kathy Beatty from November 29th, 2016?
Yes, just today.
Was Ms. Beatty your point of contact at the hospital?
She was.
Was it apparent to you upon reviewing the email discussing the phone conversation between Beata Kowalski and Maya Kowalski from November 29th, 2016, that Ms. Beatty was monitoring or listening in on the phone calls?
Object to the form, Your Honor.
Overruled. You can answer it.
Yes.
I want to move to those items that you disallowed and that you allowed in your role. To be clear, you excluded from Maya Kowalski the razors. Is that right?
That is correct.
And I wanted to clarify on the communion. When communion was discussed, what you excluded were communion wafers, correct?
That is correct.
Generally, and defense counsel just read the list there, you let in things like deodorant, body wash, nail polish remover, chapstick, a nail file. Was it your general policy to allow in items that were for Maya Kowalski's health, well-being, bath needs, etc.?
Yes.
Was there ever a time where you disallowed shampoo for Maya Kowalski?
No.
Was there ever a time that you disallowed chocolate cake for Maya Kowalski?
Oh, my computer froze, sir.
I think we saw that, yes. I'll repeat my question. Was there ever a time that you disallowed chocolate cake?
No.
Was there ever a time that you became involved in excluding from Maya Kowalski her Tommy Hilfiger Christmas dress?
No.
Did you ever disallow Maya Kowalski to have her prayer book?
No.
Did you ever disallow Maya Kowalski from having her rosary beads?
No.
Thank you, ma'am.
Thank you. Just briefly, Your Honor.
Yes, ma'am.
First, the phone call that was referenced in the November 29th email was a phone call on November 29th, 2016, correct? That was...
I don't recall. I just read that now.
With respect to outside food, was it also, was DCF also monitoring whether or not outside food could be brought into
Objection.
Maya's room?
Foundation, predicate, speculation.
You can answer that question.
Can you repeat the question for me?
Sure. Was it also a fact that DCF would be monitoring outside food and whether or not outside food could be brought into Maya?
I believe we were monitoring any items that were in and out of the hospital for Maya.
Okay. Your Honor, can we approach briefly?
Yes.
Okay, so I'm not going to, this isn't an objection. Because she's asking the questions and asked to the approach, she's probably trying to go into an area that is in gray area. And most of this gray area has to do with the Chapter 39 stuff. So we'll see if she gets another question in. Big shout out to all those who came over from Law and Lumber. Thank you so much for being here. Rob's fantastic, and what he did for us last night with a shout out was amazing. It really was, and it's very much appreciated. He didn't need to do that. He's just that cool of a guy. I hope I can live up to the good praise he gave me, though. I think he was a little more generous than I deserve. Chapter 39, that's a code phrase, Little Miss, that we use every time we talk about the dependency hearing issue. The court proceedings that involved around the custody of Maya and removing her from the family. That's also an area that the judge is trying very hard to not get into, to separate from this case, but it's difficult. The funny thing is, at the beginning of the trial, the defense was very adamant. They didn't want that in, and now they want to get closer to the line.
Ms. Masica, can you still hear us?
Yes, can you hear me?
Yes, I'm going to give an instruction to the jury. Members of the jury, the parties have agreed that the telephone call being referenced just now occurred on November 29th, 2016. Anything further, Ms. Crowells?
No, Your Honor.
Anything further, Mr. Whitney?
Not this time.
Now, don't go anywhere, Ms. Masica, because the jury might have questions, so just give me a second, and yes, there's going to be jury questions, so.
So sometimes we can hear these jury questions and sometimes we can't. I think they're going to, I wish we had a wide shot of the courtroom instead of a close-up on Maya.
I'm going to put you back on mute, ma'am. You will not be able to hear us.
Okay.
Yeah, we're going to be muted. I'm listening to the Zoom feed as well. Sometimes the cameraman makes different choices about what mics are turned on. These jury questions have been really insightful. Prior to lunch, Mr. Shapiro was objecting to the judge, saying, "We've got a hostile jury. we've got hostile jury. I've heard hostile witness before, but a hostile jury." And the judge said, "I don't think that's the case." Ooh, heard laughter. I wonder if that was from the bench regarding a question. Yes, Rob praised all of chat, and they deserve all of it. I will say he nailed it. Chat, the mods do a great job. They deserve all of that. I'm trying to live up to what he said, though. This is the type of camera work that got cameras thrown out of the Lori Vallow trial up in Idaho. The close-up, no eyelash will fall unnoticed. Close-ups. This is more. I can see showing her at times. There are times when it's appropriate, even when it's hard to show her. It's times that it tells what's happening in the courtroom and might be, a brief video or a brief shot of Maya might be appropriate. But she's our screensaver mode that they're defaulting to is not. Show us the seal. Show us the door closer. A wide shot of courtroom. Even a wide shot of them up on the bench. I realize that would be a little trickier because some people do read lips and sometimes they don't want. That's a concern. But as a cameraman myself, I'm disappointed that this is the default they go to. Show us the Alien laptop. This whole trial has been sponsored by Alienware. That computer you see there with the blue LED glowy bit on the back. It's typically considered a gaming laptop, meaning its primary purpose is to play, like first-person shooters, Call of Duty, something like that. It's funny to see it being used by a lawyer because it's
Ms.
lawyers should be
Masica,
able
I've
to
got
afford
a
it.
series of questions
like
from the
overkill for the
jury.
use.
I'm able to ask all of them but one.
Good.
Okay.
Why did you let computer workbook in when you did not let her have her laptop?
I don't recall there being a specific reason between one or the other.
Okay. Next question. Was the communion wine or crackers in a sealed package?
That I don't recall.
Next question. Did anyone ever test the outside food for ketamine if they were worried that ketamine was being placed in those items?
Not that I'm aware of.
Okay.
We've had that question
Ms.
before.
Crowell's, anything in follow-up from the jurors' questions?
No, Your Honor.
Mr. Whitney.
Yes, Your Honor.
Ms. Messica, please correct me if I'm wrong. Are you in Sarasota as you sit there?
No, I'm in Bradenton.
Bradenton. And is that where your office was in 2016?
No, my office was in Sarasota or Arcadia or Northport.
And at the time of Maya Kowalski's sheltering, did you go to Johns Hopkins Children's Hospital on any occasion?
No, I did not.
And is that the reason you don't have knowledge as to the status of the communion wafers, whether they were sealed or whether food was tested?
That would make sense, yes.
Thank you.
You're welcome.
There's more questions from Ms. Crowell's, and I think the jury as well.
No, Your Honor.
Okay.
Wait.
Okay, so looks like I've got a couple more questions coming from the jury, so I'm going to place you back on mute, okay?
Okay.
There are lots of reasons why a witness may not be physically there. Her schedule, she moved out of the area, she's unavailable. I mean, I think in this particular witness, I think she had other work that she had to do that would cause major conflict. And it's done by agreement on both sides that she can appear via Zoom. They argue these before the judge sometimes, and sometimes it's just just like, sure, that's not a problem. They'll allow it. Yeah, but her not being there physically shows that the decisions that were made may not have been, her driving that necessarily. That puts Kathy Beatty sort of at the forefront here.
That was it?
I thought there were 2 sheets.
Nope, just one sheet this time. Ms. Messica, can you hear us again?
Yes.
Great. Did you have an assigned single contact at Johns Hopkins Children's Hospital?
It wasn't specifically assigned, but I did speak majority with the social worker, Kathy Beatty.
Okay. Did more than one Johns Hopkins Children's Hospital employee contact you, and who were they?
I don't recall. I could have spoken with nurses, but I can't, without seeing, my notes or files from the investigation, be able to clearly answer that.
Thank you. Ms. Crowell, anything further?
Just briefly, Judge.
Ms. Crowell.
So you testified that you didn't get over to the hospital, but do you recall Ms. Nihas was working and at the hospital assisting with supervised visions with Mr. Kowalski?
Yeah, she was employed by the Safe Children's Coalition. She was doing visitations.
Okay. And do you recall that she was the one on that October 26th date when the question came up with regard to the communion and what could be let in and what could not be let out of the room?
That is correct.
Okay, thank you.
You're welcome.
Nothing further.
Was that leading?
Anything else from the jury? Seeing none, may Ms. Masica be released from all subpoenas?
Yes, sir.
Yes, sir.
Okay, thank you very much, ma'am. I'm going to go ahead and turn it off for you. You're free to go.
Thank you.
Bye now.
Sometimes the judge kicks people off. As soon as he says free to go, he's like, kick from the room, and they're gone. We saw that before. Okay, so I think we're headed into depots now.
Fix that. Thank you.
Can we approach her?
Sure.
Okay, so I think we've got mostly depositions for the rest of the day. I don't think we have any more live witnesses. Now, I think the defense is doing this strategically. These depots are being played right now, and because the time that's allocated to the depo for each side is already set. Okay, it's already determined. You're not going to shorten or lengthen the video at this point. And as that plays, it's ticking time the plaintiff's clock, and it's going down and down and down. We've already had 16, 17 minutes of cross of one witness today. I did not time Mr. Whitney here today on this last witness about how long he followed Miss Lindsay Massica, or cross Lindsay Massica, but these minutes are adding up. And if they add up to more than an hour each day, I'd say if they're more than 45 minutes each day, that would be a big concern to me, where they only have about 10 or so hours left, and we have more than 10 days. So just doing the math, the simple math. I'm not big on math, but it doesn't seem to add up right now, so they have to be very cautious. I will say that was very, very good and right to the point. So I think he did a good job there. Jury can't ask questions from depots. They can't, so that helps. Yeah, not everybody that was that appears by video deposition is passed. Some of them were sick. Some of them were out of the country or out of the state. There are many different reasons. I believe one or two of them had passed away, and I'd have to go back and see who it was exactly. But that was the reason for a couple, at least. Can't plaintiffs say they don't want their questions on Depo played? Yes, but I think both sides gets to say this is what we want in, whether it's read by the other side or this side, right? This is my understanding. Maybe Rob should answer this one if he is able to. I think both sides have to say this is the part of the deposition that I would like included, or this is and this is the part of mine that you can cut out. And then, of course, all the motions that are made during the deposition are also trimmed, so you lose a lot of blank time. I was surprised earlier today we had one deposition where the judge actually said stop the video because we're wasting time, and it was Mr. Anderson thinking about the next question. I'm surprised that part wasn't trimmed out because it was only 10, 15 seconds, but that might be 10 or 15 seconds. It could be really useful come closer to November 9th.
Ms. Krause, the next defense witness, please.
Yeah, thank you, Your Honor. We're going to call by video Jack Kowalski.
Let me do the lights. 27.
So this is a video deposition of Jack, who is in the courtroom.
Told Detective. Is it your contention that everything you told Detective Graham when you met with her back in November of 2016 was not true?
Everything I said to her was true.
Your Honor, the next witness we're going to call is Dr. Gatti Revivo by video. His deposition was taken on November 8th, 2021.
I missed that. That was so fast.
Members of the jury, my understanding this is a 55-minute ish. And so we'll take a break after that deposition.
Doctor, will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
Yes.
Dr. Revivo, can you please state your name and professional address for the record, please?
Yeah, Gatti A. Revivo. I work at Shirley Admissibility Lab at 355 East Erie, Chicago, Illinois, 60611.
Just, where you went to college, your degrees, and then where you did your residency, fellowship, things of that nature.
Right. So I went to the University of California, Davis, for an undergraduate degree in exercise physiology. Went to medical school at the Pacific College of Osteopathic Medicine of the Pacific, and then followed by a residency in adult physical medicine and rehabilitation here at the Rehab Institute of Chicago, followed by a one-year fellowship in pediatric rehabilitation medicine, followed by employment at Rady Children's Hospital 2002 to 2008. Upon my return here to Rehab Institute of Chicago, now known as Shirley Admissibility Lab, with interests in obviously pediatric rehabilitation medicine and a focus on spasticity management, inpatient, and also chronic pain management.
Talk to me a little bit about your background in pediatrics. I understand you have fellowship training in rehab physiatry. Is that correct?
The fellowship is specific to pediatrics as it pertains to physiatry.
Okay. Is there a difference between, and I know this is probably somewhat of a general question, but can you just generally outline why we have a pediatric fellowship training track for those who are going to be dealing with pediatric patients?
So, the physical medicine rehab residency is a 4-year program, including your first year, which is internship. Typically, though, that is adult-based with a few months of pediatric exposure. So for those of us that have an interest in pediatric PM&R, you do a fellowship for further focused training.
As part of your training and your practice back in 2015, 2017, did you have the occasion to treat pediatric complex regional pain syndrome, also known as RSD, reflex sympathetic dystrophy?
Yes.
Would you consider yourself an expert in the treatment of complex regional pain syndrome?
Yes.
Okay. Approximately how many cases of pediatric complex regional pain syndrome do you believe you've handled up until the point you encountered Maya in 2015?
2 a year, 3 a year, by 15, probably 30, 40 cases.
Okay. Would that also include some exposure during fellowship?
Yes.
I think I heard you say during that explanation there that your program is physiatry based and non-injection mediated. Did I hear that correct?
That's correct. Sorry, one last thing. The other big component of the program is the cognitive behavioral strategy. So, of course, using the cognitive strategies to improve on pain management. So biofeedback, mindfulness, pacing techniques, sleep hygiene, looking at the stressors in the social milieu, whether that's in the home or academics.
Okay. In terms of the cognitive side that you just described, is that the same as the term cognitive behavioral therapy?
That's correct.
Since there's been an objection, can you just label what the 3 standard general modalities are employed at Rehab Institute of Chicago back in 2015 and 2017 for the treatment of pediatric CRPS?
Cognitive behavioral therapy, occupational therapy, physical therapy.
Fair enough. And I think you said that there are times where you have involved anesthesia to engage in blocks. Did I hear that correctly?
That's correct.
Okay. And what do you mean when you say a block?
Well, so a couple of my partners there at Lurie's, and again, we're not partners in the sense that we're employed by the same institution, but we work on a lot of the same patients. Mm-hmm. So I'll send these patients if we're not making headway in reducing the allodynia or hyperalgesia. So typically I will send them to the pediatric pain anesthesiologist to determine whether or not, a centrally mediated block to change the sympathetic overflow in the patient's body, or potentially a specific nerve, either nerve root level or peripheral nerve, that will desensitize basically or anesthetize the lower extremity. That will then allow my PT and OT group to promote the strategies used to improve on the patient's function.
Approximately how many times have you involved anesthesiology in the treatment of a pediatric CRPS patient at the Rehab Institute of Chicago?
In that time period?
Ever?
Yeah. Maybe directly handful of times, 5, 6.
In those handful of times, do you ever recall any of those anesthesiologists using ketamine to treat complex regional pain syndrome in a pediatric patient?
No.
So I think it's fair to say, doctor, that within pediatric circles, you do not consider ketamine to be a standard of care medication for the treatment of pediatric CRPS?
Correct.
Okay, and why is it that you have that opinion?
Hasn't borne or proven its efficacy. I'll leave that to the anesthesiologist to utilize based on their clinical acumen and whether or not that makes sense in their domain of treatment.
Did I hear you correctly that you do not refer patients to providers that use ketamine to treat pediatric CRPS?
No, I did not say that. What the anesthesiologist that I work with at Lurie's, that's not in their treatment armamentarium. We've never had that conversation. So
okay, there. I guess the better way to ask the question is, to your knowledge, the anesthesiologist that you work with in terms of pediatric CRPS, to your knowledge, they don't use ketamine to treat pediatric CRPS?
That's correct.
Okay. Why don't you tell me a little bit about the Shirley Ryan Ability Lab, that was formerly known as Rehab Institute of Chicago? What type of services do you guys offer? Why does the organization exist? That type of thing.
So we're a freestanding rehabilitation hospital that provides service to pediatric patients, to adult patients. We have service lines of care, including inpatient rehabilitation, where patients are admitted typically from another institution, typically acute care. We have a day rehabilitation model where patients are well enough to be in their home setting, but need an intense level of therapeutic milieu, so they may receive some combination of PT, OT, and speech therapy. We also have a large outpatient clientele. So in my specific line of work, I see obviously children with cerebral palsy, spina bifida, traditionally on the outpatient service. We have a large, vibrant inpatient service, primarily made up of kids who've had traumatic injuries, whether it's TBI, spinal cord. And I do see patients in the day rehab milieu as well.
Okay. Did you review anything in preparation for today, Doctor?
No.
Did you have an opportunity to review your progress notes that we're attaching as an exhibit?
I did.
Okay. Did you have a chance to review some of the emails that I've attached as exhibit 2 and 3 that we'll talk about a little later?
I did.
Are you familiar with any facilities in the United States that do what's known as a, quote, ketamine coma procedure for the treatment of pediatric CRPS?
No.
Have you ever heard of a Dr. Anthony Kirkpatrick?
No.
Have you ever heard of a Dr. Ashraf Hanna?
No.
Are you familiar with any publications by Dr. Anthony Kirkpatrick and or Dr. Ashraf Hanna in the field of the treatment of pediatric CRPS?
No.
Have you ever heard of a pediatric patient receiving up to 23 milligrams per kilograms per hour of ketamine for the treatment of pediatric CRPS?
No.
I guess my first question for you is, do you recognize what Exhibit 1 is?
Yeah, it would be a consultation that we provided for this patient at Lurie Children's Hospital as they were an inpatient back in 2015.
Okay. And I believe the date of service here was 7/23/15, is that correct?
Correct.
Is it my understanding that you would have actually personally interacted with Maya Kowalski in preparation of this note?
Correct.
Okay. And Dr. Rojas would have had some involvement as well?
That's correct.
Okay. And so that's Lurie Children's Hospital on July 21, correct?
Correct.
All right. And then it says here in your note, after reviewing records, Maya continues to have low cortisol levels, but a thought not to be related to her symptoms. Do you see that?
I do.
What are you explaining in that portion of your note?
Just the fact that it was reported that she had low cortisol levels.
Okay. Any idea why that was not thought to be related to her symptoms?
No.
Let me ask you this, Doctor. Separate and apart from the information in your note or the emails that I sent you, do you have any independent recollection of your interaction with Maya Kowalski or her mother, Beata Kowalski, back in July of 2015?
No.
Well, let's go back with your note here. It says, do you see where it says, today Maya is in pain? Do you see that?
Yes.
Okay. And then it says, quote, she describes the pain as constant and involving her entire body, including legs, back, head, and arms. Do you see that?
I do.
Is that the type of pain presentation that you would typically associate with the patient with pediatric complex regional pain syndrome?
No.
And why is that?
For the very nature of the definition, it's complex, but it's regional. So typically we'll see patients who present with a limb, so maybe a foot or a leg. I have seen patients that may present with a kind of hemiparesis presentation. So they'll present with a limb and the trunk. But this is a different diagnosis based on what we're saying here, based on my experience.
In your experience in treating pediatric CRPS, have you ever seen a whole body or entire body case of CRPS?
Well, I've seen plenty of patients that come in with whole body pain.
Okay.
The question is that CRPS? So in my, if you want to talk about semantics, complex regional pain syndrome, based on the strict criteria, is a regional component of the body. Someone who comes in with widespread pain, that's not how I would describe the ICD-10 coding.
And when you say regional, you mean you expect maybe to see it in a patient's leg, but not both legs, torso, arm, and head?
Correct. I have seen patients that, again, no patients potentially follow the textbook, and you have to be creative in medicine. And we've seen patients where they'll start with symptoms that may meet the criteria for CRPS in one limb, and now they're starting to have the same symptoms in another limb. But I have a different definition for someone who comes in with, as we've described in this, entire body pain.
Do you see a description there that says prior to admission, age appropriate, independent, current functional status, she is unable to sit up independently. Mom carries her to wheelchair in order to go to bathroom. Do you see that?
That's correct. I see that.
And did you draw any opinions with Maya Kowalski about what type of care she would need?
Clearly, she's not able to sit up independently.
And my understanding is you would have done a physical examination of Maya Kowalski. Is that correct? All right.
Correct.
I note here in your physical examination, it says, quote, she is moaning and crying without tears. She stops moaning to answer questions. Do you see that?
I do.
What is the clinical significance of including those two sentences in a physical examination?
That allows us to create a picture of behavior and presentation.
And what picture of behavior and presentation are you describing here with the entry? She is moaning and crying without tears. She stops moaning to answer questions.
That there's clearly a behavioral component to her pain, and this is how she's expressing her pain and her grief by presenting in this fashion.
What do you mean by there's a behavioral component to her pain?
So oftentimes patients may not be able to provide, in this instance, we use FACES or the Wong Baker scale. So how do I determine the degree of pain based on some scale? So if we don't get a number, potentially then we can ascribe severity based on behavior, whether it's movement, whether it's verbal, whether it's facial, whether it's, in this case, moaning, crying.
Why is it clinically significant, if at all, that the patient would stop moaning to answer questions?
Well, it's nice to know that she can stop some of that behavior to get some composure, to be able to participate in the exam.
And then I think it says down at the end here, refuses examination due to pain. Do you see that? Right after normal muscle bulk, it says refuses examination due to pain.
Correct.
What are you describing in that entry?
Well, it looks like when you look through the components and the systems, as we went through the examination, like under sensation, refuses exam and screams with light touch. So patient did not want to participate in that, and we have to honor that during the assessment. If providing some type of sensory input is creating too much pain for the patient, then we stopped at that point during that sensory component of the exam.
Later on down under musculoskeletal range of motion, do you see where it says when asked to wiggle toes, she is able to, but breaks of and screams. Do you see that?
I do.
Okay. What are you describing there in that portion of your musculoskeletal note?
we're getting a sense of, does the patient have active ability to move any extremity, body, whether it's axial spine or the extremities themselves, and what kind of power what kind of neurologic function do they have under their own power to move a limb?
And then it's a similar question, but you see where it says strength moves UE against gravity, moves LE while in bed, but screams with movement on command. Same question about that passage. What are you describing there?
So the first part of that sentence moves the upper extremities against gravity. So we can see that she's got intact or at least anti-gravity motor function, right? So if you're ascribing a muscle grade on her own, at least 3/5 in the upper extremities. It was also noted on our assessment then that she was able to move her lower extremities. However, when we asked her to do so, obviously there's screaming involved.
And then mobility dependent for all mobility. I think we discussed that earlier. Is that your recognition that she required assistance with getting around?
Correct.
So we walked through a little bit of your physical examination here, review of systems, et cetera. And then my question was, did you, after your assessment of Maya Kowalski, come up with an impression and recommendation for steps moving forward?
Yes.
What were those?
Well, so the impression as written is that this patient has a central sensitization process that exacerbates her pain and pain amplification with behaviors. The fellow had written a decline in function attributed to conversion disorder. She has signs of pain, catastrophizing, anxiety, kinesiophobia. So again, going back to the physical, that's the behavior seen. We know that mood and anxiety are a component of pain and pain management. And then kinesiophobia, so fear of movement because movement causes pain. We determined that she would benefit from physical and occupational therapy, the psychological components, desensitization, and again, cognitive behavioral therapy. So basically said, look, we've been asked and tasked to consult on this patient and are recommending that, a chronic pain program a la ours may help this patient in her functional recovery.
You pointed out the reference to conversion disorder. Do you see that in the impression recommendation?
I do.
What is being described there by use of the term conversion disorder?
So that's an older term and certainly used back. Sorry.
My apologies. Go ahead, Doc.
So that's a term that is a little more antiquated in DSM-5 and clearly moved to something we attribute to or describe, as functional neurologic disorder or functional symptom, FNSD, so functional neurologic symptom disorder. But it's basically a collection of disorders that have a basis in organic, pain pathology with significant overlay of anxiety, mood, and psychiatric. So and the old term of conversion is what is converting? Is that you're getting a psychiatric mediated etiology to and a milieu with organic pathology. So we don't use that term anymore. And granted, we've become more eloquent in our description of patients. And frankly, what I think is interesting here is, again, this patient presents with whole body pain, which really is more akin to an accurate diagnosis of what we call central sensitization. So knowing that the central nervous system, i.e. vis-a-vis, the brain, the prefrontal, frontal cortices, the amygdala, the brainstem, not only govern, but they manipulate inputs coming from the peripheral nervous system. And basically you're getting the sensitization or neurosignature of pain. We treat patients from a cognitive behavioral standpoint many patients that now come in, and if you look at the literature from Kozlowska, might even say that patients who have fibromyalgia, CRPS, patients that have hypermobile spectrum disorder, all have some functional component. Again, that doesn't mean this is psychiatric and factitious, because that's a different whole ball of wax. Are you talking about malingering? Are you talking about Munchausen's? We're not doing that today. I think the issue that we describe in a lot of the patients that we treat is that there is this process of central sensitization that over time, with the exposure of chronic pain, the brain is changing that neurosignature it's receiving from the peripheral nervous system and actually beginning to modulate it. So a patient like this that presents with, diffuse pain that she clearly had hyperalgesia, she clearly had allodynia to light touch, is more akin to central sensitization. And you asked me earlier, why isn't this CRPS? And well, couldn't a patient who has whole body pain be CRPS? And absolutely, we've seen patients that have had more than one limb, and that isn't following the textbook. But my experience is pain patients don't follow the textbook. But it's just a continuum of the process, whether the pain is peripheral, right? And it's coming from one, peripheral nerve through the nervous system, getting regulated through the autonomic nervous system. And now you have this upregulation of a signature, a la central sensitization. And so it's just the eloquence in which you use the terminology. So we've moved away from conversion disorder. We don't describe it that way. We talk about functional neurologic disorders. These patients present with motor dysfunction. In this case, this patient, may have difficulty walking or needs total dependence in mobility, although you can see that based on components in the exam, she demonstrates the ability to actively move an upper and lower extremity. We know that patients may present with other pseudo seizures. I've seen patients who've had altered speech. Those are all functional in origin. And the confluence of organic pathology with psychologic components of stressors, anxiety, mood, alteration, etc.
It sounds like we've moved away from using the term conversion disorder in the most recent DSM-5. What about back in 2015, 2016? Was that term being used?
Yes.
Are you critical of anybody in this time frame, 2015, 2016, who uses the term conversion in their medical charting?
No.
And so we talked about your impression and recommendation here in some detail. And I think you said that your recommendation was to do the type of pain program that they could offer at Rehab Institute of Chicago. Did I hear you correctly?
That's correct. That was one of the options. And we also said, obviously, and again, I have no independent recollection of this patient, but clearly she lives out of state. And so, one of the other thoughts was, would she find something that would provide at least the nature of the way we treat our patients with pain, something closer to home in Florida.
And so what, and I know we talked a little bit about the program in general, and some of this may seem repetitious to you, but can you describe the type of program that you were referring Maya Kowalski to in terms of the modalities of treatment that you thought were necessary back in 2015?
So these would be cognitively, behaviorally based. So the core of that is changing the way in which the patient perceives pain, has a relationship with pain, and that's through the cognitive component with the psychologist, using biofeedback skills, mindfulness, using strategies to start to change that conversation around pain, coupled then with the physical and occupational therapy modalities seen fit by the provider to optimize, return in function while reducing, pain perception. So we talk about it in this case where she has evidence of pain to light touch, a desensitization process where you're actually trying to change that perception of what inputs are causing centrally that central sensitization process.
Any recommendations for any type of analgesic or pain medication?
Not at this visit.
And I think we talked about it, but your recommendations were for PT, OT, psychology, desensitization, and cognitive behavioral therapy?
Correct.
Okay. At a program such as Rehab Institute of Chicago or a similar facility that could provide that similar panoply of services?
Correct.
Okay. All right. And same question for Jennifer Richards. Who is that?
Yeah, so Jennifer Reichert, she was the clinical manager at our Center for Pain Management during this time period.
Okay. And Ms. Reichert was asked some questions about the program at Rehab Institute of Chicago for pediatric CRPS. Have you had a chance to review Ms. Reichert's responses to Beata Kowalski's questions about the program?
Yes.
How do you characterize Ms. Reichert's responses to Ms. Kowalski's questions?
It looks like there were a set of questions that Ms. Kowalski had about, if they're to participate in our program, specifically, what type of service do we offer? And she attempted to go through that process of answering those questions.
Based on your review, did it appear as if Reichert responded to these questions in an accurate fashion?
Yes.
It doesn't appear in the emails, but I did have a question about it. At the Rehab Institute of Chicago, do you have any experience with treating pediatric CRPS with the surgical implantation of an intrathecal clonidine pump?
No.
Do you recognize intrathecal clonidine pumps as a standard of care modality for the treatment of pediatric complex regional pain syndrome?
I don't.
In this time frame, January of 2017, if you were asked what type of meds or vitamins do you use for your CRPS patients, what would your answer have been?
We'll typically trial the gabapentinoids, so gabapentin, Lyrica. There have been trials using high-dose vitamin C. And certainly have a discussion with patients and their tolerance for trialing meds. We'll certainly use tricyclic antidepressants to try to change the neuropathic signature. Potentially go deep into the antiepileptics. But that's probably about as far as we'll go. So really, treatment for me specifically is gabapentin, Lyrica, tricyclics, maybe, trialing some of the antiepileptics. And, certainly there's some debate whether vitamin C makes a difference.
What about ketamine?
No.
And why not?
Look, I don't have experience with it. That's not something that we certainly use, and I've certainly not had any patients that frankly have asked about ketamine. So, if they do, I refer them to the adult colleagues down at Rush.
I've heard a lot throughout this case that the standard of care therapy for pediatric CRPS is PT, OT, and cognitive behavioral therapy. Is that a statement you would agree with or disagree with?
I treat a subset of these patients. I would not sit here today and tell you that I treat every kid that has contracted or developed CRPS. We have one philosophical viewpoint on how to treat patients with chronic pain, whether it's CRPS or central sensitization or whatever. And that's the way we treat them. I clearly realize we're in the minority. I'm part of a pain listserv. We're unique in that it's truly physiatric based with cognitive behavioral therapy at the core. Clearly, most practitioners of pediatric pain management are anesthesia based. So we're unique in that matter. I would not say that's our standard of care. I'm not going to speak for the field.
And based on your review of these emails, what was your understanding of the plan of action as of January 2017 as set forth in these emails?
I'm actually not sure. It sounds like they were maybe interested in doing the program, and I'm not sure where it got left.
Fair enough. Do you ever recall being contacted by anybody from Johns Hopkins Children's Hospital to discuss Maya Kowalski, her case, or really anything for that matter?
No. not at all.
Same question for a Dr. Sally Smith. She's a pediatric child abuse physician. Do you recall if she ever contacted you?
No.
Okay, what is the Budapest criteria?
So it's a group, and Dr. Norm Harden, who was one of our mentors and colleagues here and director of pain management, provided a construct in which to provide clinicians which a way to better diagnose CRPS and to sift through the other diagnoses where maybe they didn't meet criteria and such. You would have to figure out what the etiology of pain was, because otherwise it's like fibromyalgia was 20 years ago. If you couldn't explain it, everybody had fibromyalgia. And so attempting to become a little more eloquent in the presentation and developing a impression of the patient.
When you're diagnosing a patient or considering diagnosing a patient with CRPS, do you use the Budapest criteria in your clinical work?
Yes.
And why do you use that criteria?
Provides for a better, accurate treatment. Obviously, the reality for me is a lot of the procedure, so specifically in CRPS, the therapist may ascribe a very specific philosophical presentation of, providing graded motor imagery and mirror therapy and, attempting to decouple the limb from, this pain presentation. But it's just kind of determine and devise the treatment plan a little more eloquently.
From what I'm reading here from your consult note, you didn't diagnose the patient with CRPS. Is that correct?
That's correct. So yes, in a patient with CRPS, the PT and the OT are going to start in a very different place than maybe FND, or in this case, conversion disorder or central sensitization, and focus on, if she's not moving, how do you get her to start moving and improve on transfers and improve on mobility?
Based on your review of this consult note and your training and experience, why did you not put complex regional pain syndrome, also known as RSD, on Maya Kowalski's differential?
Well, one, the presentation is more diffuse. There isn't a specific, hey, I had some traumatic injury to my extremity, and now I've got pseudomotor changes, vasomotor changes, so I have swelling, I have discoloration, I have a temperature discrepancy between one limb and another. The rest of the body's fine, but please don't touch my right foot, because when you do, you send, electrical shock waves through my body. We're not getting any of that flavor or description in this note. So hence, the fellow at the time put conversion, and perhaps maybe more appropriately, that concept of what I described as central sensitization is more pertinent or relevant based on the presentation.
All right. So because a lay jury may hear this as opposed to specialists in your field, fair to say that your differential at this time was leaning towards central sensitization and not complex regional pain syndrome?
That's correct. And again, I have no recollection of this patient, but I can only go on this one note. Basically, not observing any of the telltale signs of changes in an extremity. In fact, this patient has normal muscle bulk. They're moving the extremities. There's, obviously, whether it's allodynia or hyperalgesia to light touch, I'm not seeing any of the symptomatology consistent with CRPS.
So, Dr. Revivo, am I doing that correctly?
You are, thank you.
Dr. Revivo, complex regional pain syndrome is a progressive disease to a certain extent, is it not?
It depends.
Well, you can start out with a few symptoms, but as time goes on, develop several more. Can you not?
You know, in my experience of patients, you certainly have had potentially, you know, the presentation of hyperalgesia and allodynia and maybe the pseudomotor and vasomotor changes. What I've seen is potential spread in the body. As far as morphing symptoms, you know, or additional symptoms, I don't know.
All right. Did you check to see whether she had the beginnings of any CRPS lesions?
I can only go based on what we have in this note, since this is the only visit we had with this patient and what we've documented.
And you are familiar with CRPS lesions, are you not?
Yes.
They're rather distinctive.
That's correct. That's correct.
And if this patient down the road were to develop those lesions, say within the matter of 3-4 months, 6 months after you seeing her, would that have some effect on your ultimate diagnosis?
For sure.
And isn't there now there are 2 or 3 different forms of CRPS, are there not? There's like Roman numeral 1, Roman numeral 2, and Roman numeral 3. I don't know how you turn them.
Well, yeah, I mean, traditionally, you know, there has to be trauma. And whether they're, you know, Roman numeral 1 and 2, at least, the dichotomy between the two is that you have EMG identified nerve damage with type 2.
Okay. And what did you check for to determine if that type of nerve damage was present?
Obviously that would be EMG, but that would be if that was warranted based on the examination at the time. So our exam specifically looked at attempting neurologic assessment of both sensory systems and motor systems. Okay. Sensory systems, obviously, refused exam, screen with light touch. So she clearly has got at least hyperalgesia, if not allodynia, by definition. Mm-hmm. And based on our examination and what she would, again, just based on what we've described in this note, allow us to do. So we noted right active movement of the upper extremity. We noted intact motor to allowing her to wiggle her toes. So in some part, we were able to assess both a sensory and a motor component on the exam.
And just so the jury is aware, in either one of these, if it's CRPS or it's the diagnosis that you had, these are not diagnoses of being paralyzed, are they?
No, you're right. You're typically not paralyzed, no.
Okay. And as we sit here today, I don't think you've had the opportunity to discuss what happened to Maya afterwards, her continued course of treatment throughout the rest of 2015 and into 2016. Have you?
No, this is my only visit with the parent and the patient.
And one of the problems in diagnosing these, if I'm reading my literature correctly here, is that many people don't believe the patient, particularly children, that they're in pain because of the way it presents. Is that fair enough to say?
Very fair. And I think that's why I talked about conversion and really moving away from that moniker as it's maybe even, perceived as pejorative in that, this functional neurologic symptom disorder, which central sensitization, if you read the literature and you ascribe to certain opinions, may fall under that, in that there is some component of functional change. Because if you state that this patient in some regard has intact motor function, but yet is dependent in mobility, then this pain is very real. And at the same time, there is a functional component, i.e., there is some function that is altered or limited because of pain. But no, I deal with chronic pain patients every day. That whole concept of central sensitization and what Melzak stated as the neurosignature and the neuromatrix is that pain is very real. What's hard to know is that you get a lot of this background noise. So you get behavior. It's difficult to examine a patient like this, but by no means does that mean we don't believe them.
And particularly you talked about the specialization of pediatrics, it's sometimes difficult, particularly with a child, if you don't know, as you just explained, how this works. It can be easy to misidentify this as a psychiatric or psychological problem, isn't it?
Correct.
Can you describe for the jury the concept of intractable pain in what you do?
I mean, intractable pain would be no relief, right? So we use the FACES scale to try to ascribe a degree of how much pain the patient is perceiving and the fact that pain is chronic and unabating.
Your diagnosis was not conversion disorder, true?
Certainly there were components of conversion disorder on our assessment with, an ICD, well, in 2015 would have been ICD-9, but the more eloquent diagnosis today really would be that concept of central sensitization. So, yeah.
And likewise, there were some signs, such as the allodynia or allodynia or
hyperalgesia.
Hyperalgesia, thank you. Present in Maya as well. And those are CRPS indications, are they not?
They are, but without the other telltale signs, as you stated earlier, I see allodynia, I see hyperalgesia. I see that in other pain diagnoses, like central sensitization, like hypermobile spectrum disorder, like fibromyalgia.
All right, so we're clear then. With your experience, what symptoms would you need, symptoms or signs, combination, would you want to see before you felt confident in a CRPS diagnosis?
Sure. Some degree of asymmetric temperature change. There may be some swelling or edema. There may be discoloration, whether it's purple or red. But you start to see some dysvascular, neurovascular changes in an extremity that are more akin to what we typically see in a traditional patient that presents with a CRPS diagnosis.
And plus like you said, the super sensitivity to touch.
Correct.
Allodynia. And then and that's kind of like a fear of being touched, is it not?
Well, the kinesiophobia is really the fear of movement or being touched. I mean, allodynia is, you lightly stroke a portion of the body and you're causing, excruciating pain, where traditionally that's not a painful stimulation.
But they think it might be, and so they overreact.
Sure.
And then of course the lesions eventually.
So,
the lesions eventually.
Yeah, I mean, in my experience, it's patients that are coming have been made. The diagnosis has been made. they're coming with the lesions. They're coming in the cam boot. They're coming in with the altered mobility, as opposed to, seeing them.
I see. So you're not usually the one coming up with the diagnosis. You're the one treating it once it's been diagnosed. Fair enough?
Fair enough. I mean, we're a tertiary center, chronic pain. These patients traditionally have seen other clinicians, whether the diagnosis is accurate or not. We've had plenty of patients where they state they have CRPS and then we disagree and say, well, you're on a continuum of that neurologically, but you don't meet all the criteria. Or traditionally they've seen, 2 or 3 orthopedists. They've been put in a cam boot and they show up to us and we're like, yeah, okay, you meet the criteria. Now let's treat you. Now you're asking about suicidal ideation and, all these other issues that may be related to pain, but I did treat at some point, begrudgingly, some of the adults in our program just because of staffing. And we had patients that said, hey, I'm going to go home and kill myself. And we had them sent to the emergency room. We called 911 and said, I can't send you home safely. Sure. Telling me that you have a plan and that you have a means. And those were the adults. I've never had a pediatric patient tell me that.
And so some of the pains with, say, the CRPS, are they a constant or can they go away and come back, reoccur?
It's very interesting because I have a cohort of a couple girls that, by textbook would be given that definition, but then their symptoms and their signs and symptoms veer from textbook. And they have symptomatic flares and they're doing well with gabapentin. And, whether it's truly CRPS at this point, or do we change the diagnosis to this concept of central sensitization? Their bodies haven't read the textbook, but yet we're still treating them as if they had allodynia periodically and hyperalgesia. And yeah, it's a very small subset.
Hey, doctor, a couple follow-ups. This is David Hughes again, counsel for Johns Hopkins Children's Hospital. Can you please list your board certifications?
So I'm board certified when we complete PM&R residency in basically, physiatric medicine, and then sub-boarded in pediatric physical medicine. So really have one board. The pediatric board supersedes the adult board. And we basically take an exam every 10 years, and then we're doing longitudinal assessment at this point.
Would you consider yourself an expert in the field of pediatric physical medicine?
Correct, yes.
Okay. There was reference made to hyperbaric oxygen therapy for complex regional pain syndrome. Are you aware of let me ask you this. Do you at Rehab Institute of Chicago employ hyperbaric oxygen therapy for pediatric CRPS?
No.
Have you ever heard of that modality being used for a pediatric CRPS patient?
Yes.
What is your opinion on its efficacy if you have one?
I usually tell families that if they have enormous amounts of money, then certainly they can use it, but the research hasn't borne out practicality, efficacy. We traditionally will use it for patients who have burns and wounds, but I treat a lot of patients with cerebral palsy. Families want to pursue that treatment. Again, if they have endless amounts of money to pursue that, then so be it. But the data doesn't bear that out.
Have you ever had a parent come to you at Lurie's or the Rehab Institute of Chicago and ask for their child to be placed in a medically induced ketamine coma down in Mexico?
No.
Have you ever heard of one of your patients going down to Mexico to do that?
No.
Are you familiar with a Dr. Fernando Cantu down in Mexico?
No.
And I think you said you've seen some of these lesions in pediatric CRPS patients before. Is that correct?
I have.
What do these lesions look like in your experience, specifically on pediatric CRPS patients?
I think to be really specific, these patients, they present with a, let's say, for instance, the leg. there may be a discoloration, maybe somewhere between purple and red. There's temperature differences. There's some swelling. I've had one patient, if you want to say the word lesion, he was an adult, and this is at the time that I'm still seeing adults whose limb basically was black and purple. So, that may be more along the lines of the textbook lesion, but the lesions that we're treating are the signs and symptoms that are more ascribed to, this waxing and waning, discoloration of the limb, and temperature difference and swelling.
Okay. Let me screen share an image here for you, and I'll represent to you that this is an image of Maya Kowalski taken on, I believe, January 1 of 2017. Its base number is JHACH014768. I'd like to attach this as an exhibit. Do you see the what I'm circling here on the right forehead here?
Yes.
Does that appear to you to be consistent with the type of CRPS lesions you've seen in the past?
No.
Why not?
Because it isn't. It looks like a scratch.
Okay, so why does it look like a scratch to you?
Because it does. It doesn't look like it's CRPS. There's no swelling. There's no edema. It's on the forehead.
You mentioned EMG nerve conduction testing in your testimony. You remember bringing that issue up?
I do.
Let me ask you a hypothetical, doctor. Say, for example, 1 month after the Lurie's presentation at issue, Maya Kowalski underwent an EMG at an outside facility, and that was negative. Knowing that, how would that impact your assessment as to whether or not Maya Kowalski did or didn't have CRPS?
Well, I think in fairness, I wouldn't give her a diagnosis of CRPS type 2, but solely based on a negative EMG. That doesn't mean she doesn't have CRPS type 1. Just tells you that there isn't nerve damage.
Would you consider a study where the average female age is 39 and the average male age to be 43 years of old to be a pediatric-focused document?
Well,
why not?
Because pediatrics is 0 to 18 years of age.
Fair enough. Have you ever had a parent, or anybody for that matter, refer a child with a CRPS diagnosis to hospice?
No.
You saw some characteristic CRPS-style skin lesions during your assessment with Maya Kowalski. Do you think that's something that you would have documented in your progress note?
Absolutely.
All right, that concludes the depo here. I think the jury's going to get a break. They're going to be sent back to their room for a bit.
That light comes on really fast, doesn't it? So now that I've blinded you, it's time for your break. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. Let's try to keep it to about a 10-minute break.
Jury exit.
All right, so the jury, we're going to talk here in a bit. The judge is going to be back. We don't get much time to talk, but I want to talk about this witness. Hopefully we'll all get a break. Is that fair? Judge, can we all get a break? Because it's going to take more than just 30 seconds to mention what I wanted to say about this particular witness, my impressions. I would say good job defense on this witness. Good job defense.
It's a thank you note for the birthday.
Oh, nice.
They even drew little balloons and signed the juror number. I don't want to say the juror number, but it's the juror number whose birthday is.
That's nice.
Yeah.
They didn't thank you for the unbirthday?
Actually, no. We got to do something about that. But it does say it brought a smile to all of our faces, so perhaps it's implicit in the note. So, in any event, any issues we need to address before we.
Just a quick discussion, Judge, on timing. Unfortunately, the next witness we have is another video deposition.
For how long?
That's the really unfortunate comment. It's 2 hours.
Well,
that hurts in the afternoon.
Okay.
I just wanted to let the court know. Maybe they could stand up and stretch it 1 hour or something.
That's fine.
I'll ask him to break.
Anything else?
No,
Ms.
Your Honor.
Lawrence?
Nothing.
I love
Let's take
that.
a 10-minute break, and let's try to keep it at 10 minutes if, in fact, we've got a 2-hour deposition
Ms. Lawrence, do you
in
have
our
anything from your
immediate
side?
future.
Yes, Your Honor.
Yes.
We'll be in recess 10 minutes.
Okay, so quick break here. While they're at break, let's talk a little bit about Dr. Rivero. I'm not sure if it's a or an O in the end. This was wow. I'll say this: there are some days when you listen to trial, and you feel like at the end of the day, they better dang well give you your attorney's license. You know, that's if you can sit through that and listen to everything and it makes sense to you, you might as well just be handed your bar card or something. Today, with testimony like this, we should all get a little MD at the end of our name if we can follow everything that's going on. This for me was pretty heavy. I can follow a lot of it, but this takes. I mean, this is a very good doctor I would say in the prime of his career, who has a lot of expertise and knowledge, and as a witness, the reason why I think he was so good was because there was no confrontation. He was just as ready to answer a question from the defense as he was from the prosecution. He was answering based on his notes. He said right at the very beginning, I have no personal recollection. I don't remember this girl from anyone else. There's nothing about my visit with her that stands out. And that would say, oh yeah, she was the one who yelled when I tried to put the blood pressure cuff on. Yeah. No, there was none of that. He's like, the notes here, they just are what they are. I'm telling it like it is. So he came, it felt like he came from an unbiased position where he said, you've asked me to go back in time and I'm pulling out my notes and this is what it was. And I can just tell you what I wrote down here and that's what it is. And that to me seems believable, especially when you look at some of the other witnesses where they had a lot of hostility in cross-examination, and even the way they worded their answers, you could tell that there was a side they were rooting for, right? This one was just straight there. Now, he saw Maya before she was diagnosed with CRPS, fairly soon before she was diagnosed, and he looked at this and he says, I don't think it's CRPS. I don't think she has it, and I'll tell you why. First of all, like we said before, the regional is capitalized for a lot of these doctors. If it's not regional enough, they say it can't be CRPS. It's usually in one extremity. He said it might be hemispherical. I mean, it could be both legs or one side or something like that. Maya had a more diffused, I think was the word he used, diffuse presentation. And he said because of that wouldn't be CRPS. And he had this other term. Now he did not say at any time he said this, she's not feeling pain, she's faking this. He said that he thought it was a central sensitization, where because of pain that she has experienced, the brain has sort of rerouted those pathways, and more sensations are being reported to the brain, or more sensations are being perceived as pain than our actual pain signals, which sounds like awfully close to some of what we've heard from CRPS, where you have to reset the brain, this ketamine coma, to get the brain to reset and accept those signals back as just the signal that it is instead of the pain. So it's a fine line he was walking, but he was very adamant that this was not. He would not call this CRPS. It would be something else, similar to, but that she was feeling pain. Let's see, I'm trying to see your comments here, and Rob sort of gets precedence because he's the smartest man in the room here. Alas, here's the rub. How does this get the hospital away from a 48-hour supervision issue, photographs issue, and other conduct well admitted? I would say it doesn't. There's behavior that I think they're on the hook for that is pretty well proven, and by some pretty solid evidence that the plaintiff has put on, and this might get them out of some of the malpractice side of the accusations, but there's behavior here they're on the hook for. Let's see, what else do we have? He was strongly opposed to ketamine. Like, that was the one answer that he just about jumped out of his chair as the question was being, I mean, ketamine hadn't really even escaped the lawyer's lips, but he's like, no, I wouldn't recommend ketamine as a treatment. But then at the same time, he's like, I just don't do that. I don't know much about it. That's not something we do. Yeah, that's not something we do here. The questions about, do you even know this doctor? Do you know Dr. Hannah? Have you ever heard of this place in Mexico? These are little fake questions to me. Yes, he's in the field. You could expect a doctor to be knowledgeable about other people in his same field, but the fact that he doesn't know a specific doctor doesn't mean that doctor is a quack and doesn't have any credibility to them. Let's see. Anything else? Notice Mrs. Lawrence was sitting in first chair. Yes, and the judge recognized her before break. That was awesome. That's really cool. That is really cool. She's going to remember today, like Rob, you shared that example of your situation when the judge recognized it. She's going to remember this trial for a long time. Can a directed verdict happen at any time in trial, or is it just when a plaintiff arrested? I think, well, there are a couple, Amanda. Usually the judge rules on a directed verdict motion, and we had those, ironically, I think we had them from both sides, because Mr. Anderson made that motion, which I had not seen before from a plaintiff. But we saw them from the defense when, now his name just escaped me. Mr. Not Aldenbrandt? Is it Aldenbrandt? I think it's Aldenbrandt. He made motions for directed verdicts on several different allegations, and some of those are still being held under advisement. The judge is he hasn't ruled on them. He doesn't just all of a sudden just rule on something. It'll happen, and he's trying to get those taken care of. But so I guess those could happen at any time. But there's Miss Lawrence. We saw her. She's still smiling ear to ear. So. He said he didn't prepare for all this Depo yet. When he was asked, he reviewed several things, and he said yes. Little tiny gotcha. If I was going to go back and listen to that question, did it have the word today? Have you reviewed anything for this today? I thought the word today was in there somewhere, because when he said that, it sounded like, hey, you said no, but then yes. Yes, he did review his notes. That's not a big thing for me. I don't. She's still happy. Why don't we have audio here? Judge is saying, so the plaintiff's designations are much longer than defense. Judge says, you need to be aware of your time. Judge says, and how about Dr. 27 minutes defense, 13 minutes. There's a 17-second overlap. Okay, they're fighting about the time. Judge says 17 defense, 27 defense, 13 minutes for the plaintiffs. So they're fighting over how much of the times gets a portion to each side for the shot clock. We're going to hear the totals tonight. Judge says I'll have it all totaled up tonight. Shapiro says plaintiff's counsel asked to put on the record that we're going to withdraw Dr. Scott. So they're withdrawing that doctor, the psychiatric expert that was allowed. Shapiro says, I can put on the record that just so we have a variety of depositions to play, we did file or have filed designations for Brandon Alexander and Dr. Hanna. In the event we decide to play Dr. Hanna, instead of calling him live, we just ask the plaintiff to look at those over the weekend and cross-designate so we can keep moving and be able to fill bits. Judge says, so just so that I'm clear, am I supposed to do anything over this weekend relative to those? Ms. Cruel says, Judge, just today, this morning, we sent over designations for Dr. B. Alexander. There's another Alexander. So if the plaintiff can get to it tomorrow and send the cross designations back, and we'd love to look at it this weekend, but obviously we just gave it to them today. So, and then Dr. Hannah as well. We would like to play them Monday if we can get to them. So Shapiro says we have a full day of live witnesses on Monday. I don't see that for Tuesday. We're definitely going to need some, so we just put it out there. If they decide to cross-designate, Judge says, because I want to prioritize getting a final ruling on those DV motions, hopefully by Monday, by the end of the day, so that we can get those jury instructions tightened up. Mr. Whitney says, we have a little homework to do for the court on the memos on the directed verdict, so we're going to prioritize that. And we're going to cross-designate Dr. Alexander and Dr. Hannah over the weekend, probably not till Sunday. There is something over the weekend. They also designated early this weekend Dr. Nanny Walford. And so our counter designations are like 1 line and 3 objections, so it's not extensive, but those will be with you for the weekend, and that's their additional designation. Judge says someone's going to email that. Cruel says we'll take care of that. Once you file them, our side will take care of sending that to you. Judge has understood. Whitney says one other thing for the court, we have a motion to limit testimony of their experts. We previously notified you that would be filed. It's been filed. So I'm giving you a forewarning that that's out there, and they're going to start calling experts next week, although I don't have a crystal ball. She says yes. So we'd like to have a discussion on that Monday or so, and we're filing depositions for those experts of theirs that have been deposed, so you have that information. And we'd like to discuss that early next week. Shapiro says, we ready to bring in the jury? Judge says, bring in the jury. Okay. So that was, I'm listening on Zoom. I can't show you the Zoom, and I can't let you hear the Zoom, but I can tell you what I hear. So now we're waiting for that to start. One of the things, let me show you my desk a little bit, just for a quick second. The audio is going to continue from trial, but on my screen, I've got like 3 different feeds going from trial, and I also have one on my phone as well that we're monitoring. And so if one feed drops or audio is bad, I can bounce things around. I'm also running a Fairlight audio soundboard where I can improve and raise volume. I can actually take loud sounds and turn them down the same time I take quiet sounds and raise them up. So it's fun. This is what I do. This is the nerd side of me. I love this. So I try to get you what I can. I think court should always be easy to listen to, and I do everything I can to make it that way. I think what happened there was the audio guy took a break.
I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. And has anyone approached you about this case since the last time we spoke? And have you seen any media accounts? No. Okay. And thank you very much for the nice note about the birthday and the unbirthday. Happy birthday and unbirthday for this group. And as a present for you, we've got a 2-hour deposition that we're going to play.
We're so sorry.
So we're going to dim the lights, but before we do that, since it's 2 hours, is there anyone need to make any telephone calls? Oh, I am very, yes, we are doing it on a Friday afternoon. That will take us about 5:15. So does that impact? Does anyone need to make a telephone call?
I think the judge is mindful of maybe
without any further ado, Mr. Shapiro. Do you want to try them with them on?
Yes.
Well, we'll leave them on, and if you need it dimmed, let us know. And again, feel free to move around and stretch. Okay. Mr. Shapiro.
Without taking arrows from the jury, we're calling Dr. Farhan Malik, ICU doctor, taken on November 12, 2019. Thank you.
Raise your right hand, please. Do you solemnly swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes. Please state your name for the record. Farhan Malik. And you are a physician in practice employed by Johns Hopkins Hospital? Yes. And as part of your practice, you at one point treated Maya Kowalski? Correct. And where did you go to college? New York Institute of Technology. Year you graduated? 2005. 2005. Yeah. Medical school? New York College of Osteopathic Medicine. And where's that located? It's also located with New York Institute of Technology. They're both in Long Island.
Trying to filter out the air conditioning sound.
Your 4 years there.
09. Selective.
It's a 4-year program for osteos, well as MD, right? Yes. For the benefit of the jury, can you give them a very brief description of the differences, if any, between an MD and a doctor of osteopathic medicine? Sure. The degree is actually called a DO. Yeah. It essentially is very similar to MD schooling. You just take additional courses in osteopathic manipulation, which I liken it to chiropractic. And so you have the option of practicing that when you graduate versus just practicing as a regular doctor. I was reading, I think, maybe for your medical school website, but osteopaths take a more holistic, all-person approach to the patients than MDs. Is that traditionally what the deal is? Yeah, the philosophy that I think founded the tradition was kind of treat the patient as a whole, not just the symptoms. Again, I don't know how accurate this is because I'm just reading off the internet, but osteos tend to be literally more hands-on with the patient. I mean, there's more manipulation and testing, feeling, touching, that kind of thing, and diagnosing? You take classes in the manipulation aspect of it, and if you choose to practice that, once you're done, and incorporate that into your practice, if you're in a field where you can, such as internal medicine or general practice, becomes a little different when you become more and more specialized. The area that you chose to go into was critical care with a focus on cardiac, is that right? Yes, cardiac intensive care. All right. And where did you do your residency? Newark Beth Israel Hospital, so it's the Children's Hospital of New Jersey. And what year did you, what years were those? So that would be 09 to 2012. And after residency, what did you do? I did my fellowship in pediatric critical care at the University of Texas in Houston. All right. And what year were you licensed to practice medicine in the state of Florida? 2015. What month? I don't recall exactly. I believe it was May. So at the time you saw Maya Kowalski and her October 7th admission, you had been a licensed physician in Florida for 15 months? So you made 12, May, June, July, August, September. So about 16, 17 months? Yes, I believe, approximately. You were a fairly young doctor, relatively speaking, experience-wise? Yes. And were you licensed in any other states? New Jersey. And what year were you licensed in New Jersey? That would be at the start of my, or the conclusion of my residency, so that would be 2012. So after your fellowship at UT Houston, where did you go?
Johns Hopkins Old Children.
And what was your position?
Pediatric critical care physician.
And what does a pediatric critical care physician do?
All things involving intensive care. So if a child gets admitted to the ICU for any number of reasons, trauma, sepsis, after surgeries.
As part of your residency and fellowship, did you take any additional courses or areas of study in pediatric psychiatry or psychology?
Guys, the mods take care of it. Let's just focus on the testimony.
Additional training that I received in that would have come in the form of my continuing medical education.
And do you have a list or any determination, a way for us to determine what those courses might be?
Yeah, I have a list of all my CMEs.
Okay. Let me, I think I got it here. Let me show you Exhibit 1, Doctor, and let me know if that's as of, say, October of 2016, accurate.
Yes.
And that's just going to be 1, and then I'll mark this one as 2. Well, would I be accurate in saying that, according to Exhibit 1, there was no specific continuing medical educational course devoted to pediatric psychiatry or psychology?
Correct.
So, do you remember any of them specific to any of the disorders, claimed disorders, illnesses, claimed illnesses with Maya? Did any of these quizzes involve questions about complex regional pain syndrome or RSD?
No, not that I recall, but I've relied on my medical training to when I got presented with her as a patient.
And how many of them involved identifying medical child abuse, if you recall?
Throughout my career?
No, just that first 15 months there, after you were licensed in Florida and before October of 2016. Basically before you saw Maya for this.
None.
Would it be fair to state then that as of October of 2016, you were not an expert in complex regional pain syndrome / also known as RSD?
Yes, that's very fair.
Would it be fair to say that as of October of 2016, you were not an expert in medical child abuse?
Yes.
You were not an expert in factitious disorder by proxy?
Yes.
You were not an expert in a conversion disorder?
You're listing a lot of psychiatric disorders that, no, I am not an expert in because I'm not a pediatric psychiatrist. So.
Okay. And then Munchausen by proxy, same answer?
Yes.
Not an expert in that either. All right. When was the first time you met Dr. Sally Smith, if you recall?
I don't believe I've actually ever met her.
Have you ever spoken with her on the phone?
I can't recall exactly, but I might have spoken with her regarding this case.
Did you know of her, even if you didn't speak to her or see her?
Yes.
And what did you know of her as of, say, the period before October?
That she was our go-to person to speak to if you had concerns of child abuse.
So, did you have any specific instruction from All Children's Hospital, your employer, about when to make a call to child protection as opposed to not making a call?
No. As a pediatrician, if you're suspecting child abuse, then it's your obligation to make a call. And Johns Hopkins just reaffirmed that you should follow protocol as a normal pediatrician. So she was our contact person, and I was informed that if there was ever a case that I was involved in where I suspected child abuse, that she should be contacted.
Did they tell you, anyone at ACH, that you should call her first or call the abuse hotline first?
No. I believe that I was under the impression that I should call her first.
Okay. And would that have been through other doctors or management, or
there was a contact number, I think, on our list of phone numbers for all our specialists. I think that was her cell phone.
On any of Maya's prior admissions or visits to the ER at ACH, had you ever run into either her or her family?
No.
So the first time you ever met any of them would have been on that October 7th visit?
Correct.
Did you actually make the call yourself to the child abuse team hotline? Or did somebody else do it?
I don't believe I did, no.
Okay. But it was done at your direction. First phone call to DCF.
I would have to review the records.
Okay. That's a fair answer. Okay. And do you know Dr. and I'm it's Tepes Sanchez, but I think everybody just calls her Dr. Tepes. Is that right?
Correct.
Okay. Did you know Dr. Tepes before this admission?
Yes, we're colleagues.
And how long had you worked together?
A couple of months.
What was her specialty, or is her specialty?
Same as mine, pediatric critical care.
Even though it's not really written down from what you can recall, can you just describe to me what, when you think about it, what the protocol is if you have a suspicion? What are you supposed to do?
I think I described it before. Essentially, you're contacting Dr. Sally Smith, the child abuse specialist, in conjunction with...
There's an objection.
For a moment, please.
The judge is standing right now, is looking on Zoom. So we have 1199. We're going to take just a minute and check where we are on the count. Let's see. Ugly Betty, sorry. Fine Citizen, Carolina 5-0. See clearly. Rudy Patootie. You're up next. I'm not sure what this objection is about. A couple of you have been asking about whose time this goes to, because we have the defense called the witness, and then on direct we have Mr. Anderson, and it gets a little confusing. But they might have deposed the witness, and defense wants to call him, and the plaintiff, wasn't going to. So defense calls puts the deposition up. They don't redo the deposition and switch roles, and you go first this time, and I'll go second. They just do it the one time. Let's see.
Members of the jury, I'm going to ask that you step back into the room. I'm going to see if we can try to shorten the video. I don't know. I can't promise. Please don't hold me to that.
This is great.
But,
can we watch it on high speed?
Do not discuss this case amongst yourselves. Do not do any investigation and receive no information.
Your reaction?
Okay, we're gonna ask Rob to be over controlling the speed of this next deposition video. Rob was is going to be doing a recap tonight at 7 p.m. Eastern, with a Friday show following. So Friday Night Fights after that, following at 9 p.m. I have to say I have a conflicting thing because we've got a little podcast for about an hour in there. Before and after, I'll probably be on Rob's channel watching
You're going
that.
to check those designations?
But thank you, Rob. Looking forward to hearing that. I'll have to catch some of it on replay, though. So they're checking designations right now, meaning they might have been playing the whole thing instead of the parts we said, this is what we wanted to play. This is a mistake if it got this far. But hopefully it'll... Friday Night Frenzy, I said fights. I'm sorry. I'm in the mood for a little blood sport, I think is what it is. Sorry, Rob. I've renamed your show. So, hope you'll forgive me. But yes, so 7 o'clock and 9 o'clock on Law and Lumber. Let's see. See if I can ask any other designations. Angela, this has to do with on a taped deposition. They don't necessarily play the entire thing. Some of these depositions could go hours and hours, and sometimes over multiple days. And they don't play everything for the jury. Some of it just isn't relevant. Some of it is just a waste of time, or they don't need to go into, or maybe another witness is going to cover. It may be something that that is not helpful to your case, and you're like, well, I don't want that in. But either side, once they have a deposition, they can look at it and they basically highlight it and say, I want this part. The other side says, I want this part, and they make these designations and they assemble the video based on these highlighted clips, and also rulings about objections, and then if you watch, like, what was it? Who was the witness earlier today who had the clock behind him? Was that Dr. Pitzenbarger? I think it was him. He had a clock behind him, and sometimes the minute hand would jump, as it was going around, because there were several minutes of deposition or objection or something like that occurred that got cut out. That didn't make the, it was left on the cutting room floor. It didn't make the highlights reel. We are watching a highlights reel here, and the designations are critically important when it comes to time, because each side has a time limit in these civil trials, and how much you want played goes against your time. But just because Mr. Anderson's voice is the one we're hearing asking the question, and the response is coming to that question, doesn't mean that it was Mr. Anderson's designation. It could have come from the defense. It might be Mr. Anderson asked a question that solicited a great answer for the defense instead of the plaintiff, and defense is like, we'll take that and highlight that one. So that's where it goes. Selena K says, why are there so many depositions and not live witnesses? Well, first of all, Selena, this case is massive. It's huge. The amount of data, the number of doctors involved, and these are professionals that have careers that are very demanding. A lot of them work in an area where there isn't a lot of coverage and overlap. Their patients require treatment and care, and scheduling. Just take a day off and go to court. It's not the easiest thing to do. So a lot of these people might testify from deposition. I think didn't we see a testimony by I think it was Zoom from a cruise ship on this one. Didn't we have that earlier? That was good. Ivan, thank you. Appreciate the apology. Ivan's a friend. I tell you, I love, Ivan's been able to provide a lot of opportunities for me to challenge my personal opinion. I count him as a friend. He can get a little bit on edge a little bit. I texted him and say, hey, we've got to dial that back. And I appreciate him doing that. He's a good guy. He's very passionate. He has some experience in areas that most of us don't. And sometimes when we're, I'm not going to out Ivan's experience, but he has, he's had a life that was very different than many of us have. And we love the perspective he brings here. Thanks for dialing it back and keeping it respectful in chat, Ivan. We need Dr. G for this guy. Celia, I don't know. I think Dr. G is focusing on a couple of the other doctors. Not sure if you guys want to hear this talk that's going on right now. Hang on. Whitney just said, we're going to have 8 minutes left for our case. The judge said, you think you're going to have 8 minutes left? Judge says to Whitney, you're on fumes to your time. You know that, right? Whitney says, I think we have 11 hours remaining. The judge says, I have to back out all of this designation, so I'll have to recalculate it. let's just send the jury home today. And Carell says, I agree, Judge. Judge says, let's try to do this in a principled way as opposed to let's bring back the jury. So it looks like jury's going home today as this time crunch, time has become a factor in this case. Jury's coming in right now. So Zoom's ahead of us. Give us just a minute and we'll be caught up here. So I'm going to go back to my regular spot. All right. This is a mess and a foreseeable one, Melissa. You're right. This is something they should have sorted out. Whitney, thinking he has 11 hours, it's less.
Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did no investigation and received no information. Is that all correct? Correct. Okay. We're still going to be playing this doctor's deposition, but it's going to take a while to make the cuts to make it reduced in time. So instead of doing it now and making you wait here, in honor of the unbirthdays, you get to go home now. So, yes. But you probably want to leave soon before I change my mind. So, as a reminder, I know we're just kind of having a moment of levity there. See, you got it. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. And on Monday, just normal time. Yes. So I want you here so we can start at 9 a.m. on Monday. Now, next week, there is no day off next week. So it's a 5-day week for you, okay? Have a great weekend. Happy birthday.
Thank you.
Okay, as the jury leaves, this was a great call on Whitney's part. If this ended up being, running the clock just on their time, it would have been awful. Attorneys maybe till 6. I'm not sure if they have other things they're going to cover tonight. The judge, although he's happy with the jury, he's not happy about the delay this has caused on the trial, and we might see that right now.
I have to redo the math.
This is for the shot clock here. I'm going to count that objection because I believe Mr. Whitney made that objection to the playing of that, so we'll end on an even 1,200. But I'm not sure if it's really an objection. We'll count it.
The plaintiffs consumed, because I'm not going to charge anybody for those last few minutes with Dr. Malik. 1 hour, 15 minutes. So plaintiffs, you're now at 49 hours, 30 minutes. Plaintiffs, you used defendants, you used an hour and 45 minutes. And you're at 23 hours, 50 minutes.
50.
Yes, 23:50. They're 10 minutes away from a full day.
Ouch. They can't have these 1 hour plus days.
Now, obviously I said we were going to stay here until 6 to do exhibits, so do y'all want to take a couple-minute break before we jump into exhibits? But
just 5 minutes to organize our thoughts on which exhibits we'd like to go first. That's all right, Ron?
That's fine, but I want to try to get rulings on as many of these exhibits as possible.
It doesn't matter. We can start with where we're at and go through.
Well, I don't want to have like lots of late nights if we can help from it.
No, agreed. And do you mind if I just while we...
Oh, that's fine. Do you want a couple
Out of
minutes to...
59.
I think we...
59 hours is the new number.
So we'll be back in 5 minutes to start addressing exhibits.
All right.
Okay, let me switch the camera over here for just a second.
All right.
Okay, a little delay there. All right. So we started out, Reverend Beasy, we started out with 55 hours each. That's in the documents, the court documents. That's how much had been agreed on each side they were going to get. But earlier this week, a couple days ago, I think two days ago now, maybe 3 days ago, the judge granted, at the request of the plaintiff, an additional 4 hours for both sides, which brings them up to 59 hours. There's a couple problems with that. The problem is it did not push the actual court date that they have to end by, or that they've told the jury, we will be done by this date, which they say is November 9th. It didn't push that out at all. So they added a day's worth of time, but did not add anything to the time frame. That's a problem. And so the judges said, we've got to go faster. We've got to do better at this. We've got to get, as we're talking about evidence, we've got to do, cover more quicker. You guys need to talk to each other. Quit fighting over every little thing. I mean, you're nitpicking things that don't matter. And, you're making objections just to object when clearly, medical records are coming in type thing. And so yeah, that's, we've seen some improvement in that area. And hopefully this evening we'll probably get a little more argument. So I guess that's all we have left today is argument, and it will be about evidence. But Mr. Anderson isn't here. He was not expecting this. So I'm not sure how much they can get into or what they'll have to put off, because there are some documents that he may be sort of the expert for on the team, that he's sort of been shepherding through this process, either for or against. So yes, Selena K., the plaintiff, out of 59 hours has 49 hours and 30 minutes. So they have 9.5 hours left. And we're looking at Halloween for testimony to end. This is terrible. This is terrible. You could end up with them, they're just sitting on their hands here at the end of the case. I don't know if the judge is going to grant more time, of what's going to happen. They're going to end up, just clipping out everything that the plaintiff wants out of the depositions, and just you get it's like closing statements for days, but only from the defense side. Closing arguments for days. Man. The judge told them all of that before. The judge told them from the get-go to be mindful of the time. And early on, he would say, usually it was to Mr. Anderson, he's like, hey, just be mindful. You've used a lot of time on this. And he's like, we know what we're doing. We know what we're doing. We're getting out the important things. But those little minutes here and time there and shuffle, look for paper here and long pause between questions there, it's adding up and adding up and adding up. Now, it's possible that by the end of this case, the defense also is running out of time, right? I don't know if you can do that in the time frame, but they probably also have more material, much more material than they want to include here. I don't know if the judge can grant more without the defense flipping the lid. Yeah, Creed, they put up a pretty strong objection this time. The judge didn't seem to think that was a problem, but Kathleen says, I couldn't be on this jury. I would be looking at social media to find out what the heck is going on. Kathleen, you could not be on this jury. That is not allowed. We can't have you doing that. We do have, almost every week there's somebody in chat. It's like, hey, I just got a jury summons. Just because you got a jury summons, it usually doesn't mean you're on a jury. Getting seated on a jury takes a little bit more luck, I think. But yeah, it's best to always follow the rules to the letter if you're on a jury. You don't want to be the reason that a whole court case is thrown out and redone. All right. The times for a trial doesn't seem fair. Trish, it's different. These civil trials are very different than the criminal trials. Very, very different. Deputy Heard. Elaine, you have 6 minutes. Who said that? It just scrolled off my screen. Long pauses. Closing arguments are different time constraint. That's helpful because I think that's important. But I imagine they probably both will have at least 2 to 3 hours on closing arguments for a trial of this length. Hopefully they can fit them both in one day. Thinking the defense is going to run the plaintiff clock with deposition on purpose. I think that's what Mr. Whitney detected what was going on, because this is a long, long deposition. All right. I think closing arguments are separate, Donna. We think that. Why are there were so many jury questions and those minutes count and are split with both sides? Yes, Widget, but that's why the judge gave them 4 extra hours. And I think he probably did his math on how much time has been spent on jury questions, and it probably was about 4 hours. The mountain the defense has to climb with the jury. I can't imagine defense has enough time compared to the plaintiffs. The defense is at a distinct disadvantage just by the very nature of going second in this case. We've heard a lot of evidence and found things that we agree with, at least feel that resonate with us during the plaintiff's case, and now they have to claw their way back. So yes, they are at a distinct disadvantage. I think it's part of trial strategy. I think they would be silly not to include time management as part of their trial strategy. Do you think Whitney's on the phone failing in Anderson? He might be.
Just in follow-up from Dr. Malik, I don't recall. Follow-up from Dr. Malik, I don't recall making those, but if I did, maybe I need to redo those. But
no, Judge, I think in our quick checking, it was our error and failure to object. So,
well, we will separate and independent of this. Given how I've been ruling and given your time constraints, perhaps you might want to relook at Dr. Malik and see if there's things that you wish to pull back save time.
We will. I suspect, I don't know this for sure, but those might have been done before the 2022 attempt at trial. We'll look at the meeting.
Okay, so.
The way he says attempt at trial. This has been a long time coming.
Judge, it wasn't you.
In any event, are we ready to move on to exhibits?
Yes, Jen. We'd like to go to, I think we've done the first and second page up to 3090, so we're just going to go in order.
I wonder if Miss Lawrence gets to make some arguments.
Well, there's still a couple on page 1.
I'm sorry?
There looks like there still were a couple on page 1.
Oh, I think
we addressed all of them. Some of them they withdrew.
No, we didn't.
Or not for later discussion.
What's Arnold?
That's one from Raymond Alexander.
Oh, that's right. That's right. Yeah, we need Dr. Alexander's testimony before we deal with 3023, Judge.
And then 3030, was that the sheet of paper that had no writing on it?
Yes, Your Honor.
Yes.
What's next?
I think we're up to 3090. I don't know what they have an objection. Do you want to see the video, Judge?
It's a horseback riding on January 16th of 2017. So
correct.
How long is it?
Got it pulled up here right now. It's 20 seconds, 25, 26.
26 seconds or minutes?
Seconds.
Go ahead and play it.
I wouldn't do that to you on a Friday, Judge.
Is this in like slow motion?
It does appear to be that way.
That's how it was produced.
If that's actual speed, that's impressive. Never seen a horse do that.
We'll take the hearsay groaning out.
Now he's got his ears for.
So perhaps someone filmed it in slow motion?
Yes.
Perhaps that's how it got to us, Judge.
I could fix that for you, Judge.
Miss Lawrence, are you making this argument?
No, thank you.
Oh, come on, Miss Lawrence.
Okay. Court will receive 3090.
3094 is another video.
No. Your face is here. I got that. Yep, I got it.
No objection.
Court receives 3094.
Yeah, we need the dates on that.
3095, another video. Another puppy video. It's a cute puppy.
I see you.
You know what Kyle does? He just lays down and then she comes and jumps on him.
Come on, please. It's okay. It's okay. It's okay. It's okay. No!
Our objection would be it's 2 days from the previous video. It's starting to get cumulative.
Judge, I think it shows much more movement.
It does. I'll receive 3095. What's next?
3096.
Go.
I already got one copyright strike from Megan Trainor for playing one of their videos.
This isn't super slow.
This is like 240 frames per second played back. Ooh.
Let me see 3097 as well.
Judge, we'll just do 3097 and not 3096.
Mr. Whitney.
No objection.
3097's in.
We don't have the dates on these yet, but I'm sure when they're presented, they will be.
Did we do 3120?
We'll withdraw that, Judge. That was like 9
You know what?
seconds.
That was
And then
10/20/17
did a whole bunch of 312
for 3097. 10/20/17.
Okay, I believe the 3120 was withdrawn as well as 3096.
Yes, Your Honor. 3124 has already been admitted. 31352 has been admitted.
3135 dash.
Yes, sorry, dash 2 has been admitted. So we have 3137.
Can you
withdraw this, Judge?
Okay, so 3137's withdrawn.
Yes. 3138 has 9 photos.
And are we going to see all 9 of them?
Yes.
These look like school pictures or senior photos or something. Tribeca Film Festival.
Relevance 403. These are drawn from the People magazine article, and here clearly the release of the film Take Care of Maya. So unless we're going to explore the context and the reason for these photographs, we think it's irrelevant, prejudicial.
Do I need a responder?
Yes.
Judge, these are photographs taken in 2023, so they're obviously relevant. They're also, given the description by the plaintiffs as to what Maya does and doesn't do, I think it's relevant that she was in New York at the red carpet. The jury all knows about the Take Care of Maya video. We all asked them about it for days, so it's not going to open a door to anything. We all asked them about it, so it's not like we're trying to keep out the fact that exists.
Well,
they also had one showing her exercising.
Can I see the series again?
And these are 2023 photos. Not 2023?
You just don't have.
Yeah, these are the first. Yeah. Judge, if we want to pare them down, we can do that.
We're going to pare them down, yeah.
Okay, all right.
The ones we want.
Okay. Yeah.
So, anything else, Mr. Whitney?
I'm curious to see which ones they want to whittle them down to, and then I might have further objections.
Well, this is not yet a ruling, but I think they're going to have to choose 3 photos, 1 or 2, 4 or 5 or 7 or 9, I think. So why don't you look at those?
1, 2. I'm sorry. 1, 2.
1 or 2.
1 or 2.
1 or 2. You're going to get 3 photos.
Okay.
Those are 1 and 2.
Yeah, we'll take 2.
We'll take 2. So you're going to, okay, and then 4 and 5.
We're only getting 3 photos?
Well, 1 was Maya individually. This is with family. They're both are laughing and smiling, so.
We'll take number 5.
And then the other one is the person I'm assuming is the boyfriend, 7 or 9.
Well, there was one of her on the exercise machine, Judge.
That looks staged.
Okay. All right, we'll take 9.
We object to 9, the Tribeca backdrop. If they need a photograph of her in a relationship, that has maybe become relevant. 7 would suffice.
No.
9 is going to introduce all sorts of issues. Although they're aware of the existence of the film, we're going to want to explore what arrangements were made for her in New York City, how come this was a comfortable experience rather than what she testified to, being out and about and seeing Kathy Beatty or people that look like her. We'll also, if these photos are coming in, want to be able to explore that all of them that are going to be admitted were staged by People magazine, and they're not truly candid shots. It's a People magazine photographer.
Judge, this is a valid photo, number 9. That they already talked about the fact they went up there for the Tribeca Film Festival. That came out in, I think it was Mr. Kowalski's testimony. It's not opening any door. The jury knows about it, and it is a different view than has been presented with regard to Maya Kowalski's life that she has presented in front of this jury, where she's afraid to go out of the house. She's afraid to do anything. This is a different view, and the defense has the right to put this perspective in front of the jury. So between 7 and 9, we would choose 9.
Well, I guess it wasn't a ruling. To me, the Tribeca Film Festival it's a collateral issue to this lawsuit. And I get what you're saying about she's out and about, but the context is a little bit different. It would seem that 7 would also suffice to help tell that story, and I think I would allow you to do 7, but I've got concerns about going down the road of pictures of the Tribeca Film Festival.
Okay, good.
Just like I didn't want, they wanted to put in the movie, and I said no.
Well, Judge, to me, putting in the movie is a whole different kettle of fish. You're talking about
You don't think I'm getting that
hearsay.
request if we start talking about putting in 9?
Judge, that's in all seriousness, that's a completely different analysis. This is one photo. They already know they went. If we can block out Tribeca Film Festival if you want. But it's a completely different view of Maya Kowalski's life that they have failed to present to this jury that the defense believes they have the right to do.
I will receive in 3138, number 2, 5, and 7, and we'll exclude the others.
Can we see 8 again, Your Honor?
You can put up 8.
She can say it's stage, Judge, but I think we should be allowed to put in 8.
2, 5, and 7. What's next?
All right. 3139.
They look so staged. They look like stock photos.
This is an
They really
email
do.
from Dr. Wassenaar to Beata.
September 9th, 2015. Okay.
Yes, September 9th, 2015.
Looks like asthma treatment instructions.
Something's wrong with his email. He doesn't have a recipient.
I'm sorry?
It doesn't.
Well, it says from Dr. John Wassenaar.
But the from at top says from Beata Kowalski.
There's no
It
2.
doesn't have a 2.
Good eye, Mr. Whitney.
So it's not, I don't know what this is, but it doesn't seem to be a valid email. I've never seen an email without a 2 address.
Yeah, Judge, we'll withdraw it. 3140. It's 4 pages.
Can you put the first 2 pages up for me, please?
Disappear so you guys can get your screenshots. A little hard to read this one.
It's from it's October 30th, 2015, email from Beata Kowalski to Dr. Kirkpatrick.
Well, I guess because it's going backwards. Let me see 3 and 4 first, because so I can read it in.
I think you're right.
I was getting weaker each day and unable to sit and roll by herself, in a lot of pain, moving constantly, not sleeping, drinking only with sips with meds. Had 2 cookies this morning. She has an appointment with you on Wednesday. I don't think she can wait until Wednesday. Could you see her by Monday, please? That was from Beata. Like Tiffany available to take calls for me over the weekend. Maya may need to go to the nearest ER before Monday. Generally, weekends a bad time to receive care and treatment. Yes, this is true.
Okay, can I see pages?
No surprise to anyone. I got a call back from Weislow's office. I guess I'm done
1
with
and
him.
2, please. The timing seems a little different. Maybe they didn't respond to like the last email.
It's like 2 responses were to the original email and not the chain.
Sorry, I don't recall what the date was on
On page 3, it was at 5:50. So I suspect what probably happened is she took an older email and then responded.
Right.
This is 2015. It's the time frame with all these communications, and it's really hard to read. It's like Times New Roman.
Right, because on page 3, if you
Light
put page
font.
3 up, there's a later email saying, surprise, surprise, there is no response from Will C's office. I'm done.
At 5:40 p.m.
Yeah, that must have been what had happened. What is the plaintiff's position?
Our position is it's hearsay without exception.
Seems like she's trying to get
Well,
medical care and treatment.
Perhaps some statements from Beata Kowalski could be for purposes of medical treatment, but certainly not all of them. She's relaying what a nurse practitioner with Dr. Willsey's office allegedly told her. That's hearsay without exception. Dr. Kirkpatrick's communications are hearsay without exception. The exception for medical treatment is as to statements made by the patient, not emails between doctor and patient.
Well, Judge, also goes to state of mind. You've got her saying, I think I'm going to have a stroke soon. I can't stand it. My medical treatment is being handled in Florida. Just the other state of mind.
Is the true objection here the statement, his NP told me that Willsey is uncomfortable ordering IV fluid? Is that what we're talking about?
That's one of them, Your Honor.
What else?
Within Beata Kowalski's first email there.
Can you give a date?
I'm at the top of page 1.
Here we go. Now we can see.
I mean, a lot of this is, if it's statements for purposes of medical treatment, it would be made directly to the physician. So this is Beata Kowalski venting about the treatment that she is getting by the staff at the office. Those are not statements for the purpose of medical treatment. So give me the go around, who she spoke with, that she's uncomfortable ordering IV fluid. All of these are Beata Kowalski venting. They're not statements to a physician or a nurse for purposes of medical treatment. I'll grant that the statement about Maya's condition could be a statement of present condition.
There's also a statement of Beata Kowalski's state of mind at this time, dealing with what she's going through with Maya.
I'm going to admit without redaction pages 1 through 4 of Exhibit 3140, so the whole thing will come in.
3141?
3140, pages 1 through 4. Did I
no, I'm sorry.
misspeak?
Emily Ippolito.
3140 is only
Thank you
4
so
pages,
much.
correct?
Great to have you as a member.
That exhibit's only 4 pages.
That's correct. We need 3141, please.
Okay, the next one.
Yeah. This is also 4 pages, Judge.
I'm going to hide my picture so you can get your screenshots if you need one.
Let's look. Let's put up 3 and 4 first, because it might be starting from the bottom up.
It's just a confidentiality notice on the bottom.
Okay, so 3 and
we
4
cover up all
like
the
a
legal
lab
speak.
order of some type.
Yeah, I'm not sure about 3 and 4, Judge. Can we look at 1 and 2 again?
Well, hold on a second. Before we go off, let me see what this is. The dates.
This looks like a...
November of 2015. What was?
Okay. We'll withdraw 3 and 4, and just look at 1 and 2, please.
But just for is this the time right before she went to Mexico? Was this the lab order that she had before going to Mexico?
Looks to me.
It is right before she goes to Mexico, Judge.
May I see 1 and 2?
And you can see on number 1, he specifically, Dr. Kirkpatrick says to file this email in patient's chart. So it's part of his medical record. And communication with Beata regarding medical treatment.
Yeah, I think Dr. Kirkpatrick testified to the need for this pump for acute pain on the trip down to Mexico. This is part of his medical record. So is 3 and 4, though, so it needs to come in together, since that's the way it was, that's the progeny of this document.
That's fine. We can continue. Keep 3 and 4 if you'd like.
Okay, so 3141, all 4 pages 1 through 4 will be admitted.
Okay. 3-1. Are you ready, George?
Yeah, I am.
3142. Oh, we don't need this. We'll withdraw this, Judge.
Why
3143.
why do they show and then withdraw? Show and then withdraw.
There's
Is this
four.
the same thing?
There's 4 pages.
Is 3143 the same thing as?
No, it's different.
Let's see the side-by-side pages here.
Well, then let me see 3 and 4 first. Actually, it looks like I need to put up 2 and 3.
Good morning. I've read all the updates on Maya from Beata. We'll be providing the naloxone ASAP. I can't read that one. With the last increase in demand in her demand dose, we ran out of room on the pump for further increases. If dosage is necessary, we will not have to
remind me who Dr. Shah is.
He is a pharmacist with Quorum that assisted with setting up various ketamine home medications as well as Dilaudid and the PCA pump. You'll be testifying. One of Beata's co-workers and pharmacist by trade.
Rob's going to do a recap tonight at 7.
Coordinated with Dr. Kirkpatrick.
And then he has his Friday night frenzy. No fight, just frenzy at 9.
And where was this? This was to be performed in Dr. Kirkpatrick's office?
This was for home use.
This might be going towards that home IV.
Home use is a bit of a misnomer there. This is again related to the pump that was discussed for the trip to Mexico. Home use, this is a backdoor attempt to get in the script that was previously excluded because of authenticity issues regarding terminally ill. So this is hearsay without exception. It's a pharmacist. It's not for purposes of medical treatment. Beata Kowalski or Maya Kowalski seeking this out. This is a conversation not involving the Kowalski family, behind the scenes between a pharmacist and a physician.
Judge, you can see that on one of the pages, number 1, it says, please put these emails in the patient's chart. So it's medical.
I'm sorry. Go back. Have 2 of them. Rereading this, please.
All the times I say are Eastern time usually.
What is naloxone?
Can I ask where you're reading, Judge?
On page 3, I've already created an order for NALOXONE.
It's an opioid antagonist, Your Honor. It can, it is used to reverse opioid overdose because there was a high amount of terminally ill Dilaudid being prescribed around this time. And to protect against overdose, that's the medication that's administered in the case of an overdose.
And this is not talking about ketamine at all, correct?
Not yet. We're not there yet, but this is the Dilaudid was on board well before.
Can I see pages 1 and 2?
It's also known as Narcan. You may know it by its more common name.
Jessica, I do not live near the beach, unfortunately. Though I might go tomorrow. About an hour and a half, 2-hour drive.
Mr. Whitney.
Yeah, in addition to the hearsay objections previously made, relevance, as the court has spotted, has nothing to do with ketamine. And lastly, 403, because what they want to do here is suggest that Beata Kowalski was pushing for hospice care or taking position that Maya was terminally ill. And they want to suggest that through this email, which is not the case. This was back and forth between pharmacists and a physician. The pharmacists were attempting to find a way to fill a prescription or get around an insurance requirement. I'm not sure what, but it has nothing to do with Beata Kowalski or her state of mind, and it's prejudicial.
Back in November 2015 timeframe.
Yes.
Is there any evidence that Maya Kowalski, Jack Kowalski, or Beata Kowalski made any sort of affirmative statement about hospice care or being terminally ill?
Judge, it goes, I'm not aware of her contacting some facility, if that's what the court is asking.
I'm wondering, because we have a humongous 403 problem here if there's no other evidence about the terminally ill. And my recollection was it was the pharmacist, or it was alleged that the pharmacist wrote something that was not done by the doctor on a prescription. And so my recollection is there was no evidence that Beata Kowalski, Jack Kowalski, or Maya Kowalski had any statements that they were seeking hospice care or that Maya was terminally ill in the November of 2015 timeframe. So
I'll just ask to observe the one attorney per argument rule, please.
Whitney pulls the one horse, one rider.
That's fine, Judge. It's just that Mr. Hughes knows more about this email, but
I just want to know if there's any facts in the November of 2015 time period that would suggest that, other than this email based on the...
We may be getting to another email later on in the series where Beata Kowalski's involved, but again, I believe this goes to the sheer amount of drugs that are being loaded into this report.
I want to talk about, because talking about someone saying is terminally ill, we got some pretty big issues that I need to deal with. So I need to know, is there any affirmative evidence that Beata Kowalski, Jack Kowalski, Maya Kowalski, and I'll even say Kyle Kowalski, made statements about seeking hospice care, or that inquiring whether Maya Kowalski was terminally ill in the November 2015 time period?
This is a yes/no question.
As a matter of fact, is there any statement out there that you're aware of?
Statement, no, but she's clearly CC'd on all of these. And
well, I read the November 10th, 2015 at 12:17, so I need to discuss the situation. I don't see this as an adoptive admission that she agrees that Maya is terminally ill.
well, but the 9:38 a.m. email says Dr. Kirkpatrick is saying to Ms. Kowalski, I suggest you contact your local hospice care unit, and it goes to how sick Maya is at this point in time.
We do.
Based on a request from the pharmacist.
We do, Your Honor, actually. It's coming up later in the series, as I indicated. It's actually exhibit number, defense
Let's see
exhibit
it. Throw it up now.
31491. On November 10th, Mrs. Kowalski is emailing.
Can I see, is it 31491?
Page 1, yes. It's a 12-page exhibit, but...
Where am I looking?
You are looking on page 1, a little bit down, November 10, 2015, 12:17. Beata is asking Dr. Kirkpatrick whether they could discuss the situation of, quote, terminally ill.
That's the same email we were just looking at, isn't it?
Yeah, it's the same.
It's the exact same thing.
Right, but you were asking, is there an affirmative representation from Ms. Kowalski regarding the terminally ill situation?
All right, we'll go back to the, because this is the exact same
This
email.
is just her saying we have
November
to
10th,
discuss this.
12:17. Can you pull up the other one that we're
Discuss
just
the
looking at?
situation of terminally ill.
Yeah, it's the exact same email. Although the one you just showed me had a color.
What is Ms. Kowalski writing to Dr. Kirkpatrick, basically saying, I'd like to discuss this terminally ill situation, see if we can reconsider that, so we can get more medication.
No. This is an issue that unless you have affirmative evidence because of how this all comes up, because remember, we have the pharmacist writing something onto a doctor's script that then the pharmacist calls the doctor then responds to Beata Kowalski suggesting calling hospice, and then we've got Beata saying we need to discuss the situation of terminal. That is not an adoptive admission that Beata Kowalski is affirmatively saying that her daughter is terminally ill. So that issue is off the table.
But that's not why we're introducing it, Your Honor. And actually, the sequence of events that happened here was that Mr. Schott and Dr. Kirkpatrick had a conversation. And during that conversation, Dr. Kirkpatrick authorized Mr. Schott to place on Dr. Kirkpatrick's prescription, patient is terminally ill, so they could get more Dilaudid than would otherwise be able to be filled.
We are not talking about, because that's not a statement that Beata made, that Jack made, that Maya made, and even if that's true that Kirkpatrick made it, I think as a matter of 403, the unfair prejudice vastly outweighs any probative value. So I'm done talking about the terminally ill issue. So is there anything else that on this we need, because it's not talking about ketamine?
Yes, it isn't talking about ketamine. It's talking about a lot of medication. What if we redacted the terminal ill sections when we revisit this? Because we think it's important for the defense to show the amount of medication that is being requested and being ordered.
And this is Dilaudid. This is one of the most potent.
But the defense was requesting that we come back after we've redacted the emails to revisit this, because it shows a lot of heavy-duty drugs that they're giving this young lady in 2015, which is significant to the defense.
Defense is fighting for anything they can get out of here. That's a huge loss to lose that terminally ill part for them.
Mr. Whitney, if we redact out all of that discussion about terminally ill and
keep fighting, Whitney.
What the script needs to say.
Well, I'm not sure where those redactions would leave us. Is the suggestion that we begin at the bottom of page 2 with James Schott's email to Anthony Kirkpatrick and then continue into the next couple of pages? And if so, I need to review those again.
Well, perhaps, on page 1, you see the November 10th, 2015 Beata Kowalski.
Yes.
I forgot to ask that first 2 sentences, that first paragraph. Leave that in and then redact out the next 2 lines. Redact out.
Well, I would like to leave in the 4th line that says, "Thanks again for your time and understanding."
Okay. Sure. Redact out that third line.
And then we'd have to redact below that the Dr. Kirkpatrick email.
Yeah, and then redact the email before that from the pharmacist to...
all the way to the end of it regarding hospice care and palliative care, because that's all based on Dr. Kirkpatrick's understanding of what the pharmacist was suggesting, so it's all interconnected.
Right. I think the 938 email, all of that text would have to come out.
And then
the email at 8:50 a.m. on November 9th from Jocelyn Krager to Kirkpatrick
has to come out.
Would have to come out.
Right. Judge, I think what we'd like to do, we're calling, is it Dr. Schott?
Sure.
Mr. Schott?
Pharmacist Schott.
We're calling the pharmacist Schott, and so I'd like to table this until you have his testimony, because I think...
I am, if you're just going to start asking about this terminally ill issue, you're not going to talk about it unless we do a proffer ahead of time.
We'll do a proffer, Judge. Understood.
Okay.
Terminally ill has to be proffered.
We generally object to this approach, which is every time an email, the court's making a ruling to exclude an email or redact, then the defense withdraws to come back later and revisit it, and it's becoming...
I have to allow people to do proffers. I allowed you to do proffers. I have to allow them to do proffers. Doesn't mean that they're going to get it, because I think I've been very clear that I think this whole terminally ill discussion and how happened is a humongous 403 issue.
Understood.
Okay, so at this juncture, we'll revisit 43143. Okay. 3144.
Whoa, lots of text. Unfortunately, things got complicated on
This is,
Tuesday.
Your Honor, day one
Robert came back
of
bad.
the coma, and it is Beata's writing it to herself.
From Beata to Beata. This is for a blog, I think.
Was this posted someplace?
It's for a blog. It's like a blog entry.
Some of this form, if I may address this, Your Honor.
Sure.
Some of this does form the basis of the WordPress blogs, and another court wanted authentication, so we have here the email from Beata to Beata that she cuts and pastes into the blog, but at a minimum, we're seeking to admit the email that is her own writing. This was produced to us from plaintiff's counsel in response to a request for use, so it's authenticated.
From Beata Kowalski's iCloud.
Yeah.
This is written in the voice of Maya. I was told today I'm a high-risk patient for developing infection sepsis during the coma. Hundreds of angels watching over me and God working through doctors' hands and brains to get me in remission. I'm hoping for a miracle ketamine coma. This is Maya writing in Maya's voice for the blog. My mommy kept vigil on me all day long and kept checking on me even at night to make sure I was
We don't
doing
know
okay.
who wrote this email. No one's here to testify to this. It is from Beata Kowalski's email address. Ms. Kimball, who we discussed earlier, also testified to writing things like this. So we don't know who created this. It's hearsay without exception.
Let me ask you this. Was Miss Kimball in Mexico during the medical coma?
I'm aware of.
So...
But they were in touch.
Well, it seems to me the whole purpose of hearsay is to keep things out when there's not a belief that it's reliable. This has very specific information, which presumably, had we had the records from Mexico, we would have been able to verify specifically this is what happened on the blood work and all of that. So it's her email account. I'm assuming that that's her email account. And so it does seem to me to be a statement she wrote to herself. And so to me, this is a very low chance that it's not Beata Kowalski writing this.
And so what's the hearsay exception? Because it's not a statement for purpose of medical treatment.
Your Honor, it's clearly detailing state of mind. It's for purposes of medical diagnosis. It is admissions against interest.
Getting whispers from Mr. Shapiro.
She is writing as if she is Maya, and she's writing all sorts of complications related to the coma, that procedure that Maya went under, and that is an admission that contradicts the testimony that's been presented with regard to the coma procedure that Maya underwent. And the procedure is very high risk due to the fact that I have immunodeficiency, poor nutrition status. I mean, it's an admission.
And I believe statements of the decedent are admissible under party admission.
But we have clear case law on that.
Okay, well, let me back this out. Did anyone say recorded recollection? I think that one has to be offered.
No, we did not say recorded recollection, Judge. At least I don't think so. I've had whispering in my ears, but I don't think we said recorded recollection. But this is an admission. It's detailing all the complications that occurred and the concerns so the state of mind for sure, and it also shows all the complications, admission of that versus the somewhat rosy picture that's been portrayed to the jury of this coma that Maya underwent.
Certainly not for purposes of medical treatment. Beata's not writing to a doctor. And statements of the decedent under the case law we reviewed are not admissible as party admissions.
I don't know what he's referring to there, Judge. That doesn't make sense to me.
You can't put in statements by the decedent as a party
Clearly
admission.
a statement being offered against the party.
Yes.
That's the party's own statement.
Yes.
It would seem that there is an exception to the hearsay that would apply.
But a decedent.
Anything else, Mr. Whitney?
Mr. Whitney's flipping through law books right here.
Under Huff versus White Motor Corp at 609 Federal 2nd 286, and admittedly this is a rare situation, but I'm in Earhart's. Statement of decedent is not admissible against the estate as a statement of a party opponent.
We're not admitting this against the estate, Judge. We're admitting this against her.
Well, what was your cite? It sounded like a federal case.
It is, Your Honor.
It's under 609?
609 Federal 2nd 286.
Citations are powerful with a judge. This is precedence. This is the guidance the judge is trying to follow, because no judge wants to venture out in no man's land and get reversed. So if you can cite some case law, especially in a situation where the judge is, teetering on the edge, not sure which way he's going to rule, they can be very powerful. Defense, if they want to save this point, would be scrambling right now to find some case law as well in their favor. Yeah, the email floors me. I don't have any words for it. I think this might be the strongest red flag about MBP, where the mom is writing apparently for some sort of attention and doing so in the voice of the daughter, sort of living vicariously as a sick person through the daughter. This is probably the strongest argument that the defense has towards that. But they didn't have this at the time that she was in the hospital. This was once this was going to trial, this was produced by defense upon request, or by the plaintiff upon request. Okay, there's a ton to this, but basically this is saying the ketamine infusion got complicated. Blood work was bad. The levels were off. Adrenal insufficiency. It's the worst possible news I could receive this morning. And it's all written with a I, right? As if it's written by Maya. But, complications from adrenal insufficiency, including death. My ketamine coma got postponed for another day. I had to be reevaluated by PEDS, ICU doctor, and then consulted PEDS endocrinology for more brain knowledge. This is not Maya writing. Okay, this is not a 10-year-old girl. Maya is very smart, but that is not the voice of Maya as a 10-year-old. And so it just seems strange. This was written by Beata. It looks like it was written by Beata and sent to another email address of Beata's. So it was from Beata Kowalski to Beata L. Kowalski, and Kowalski, I should say Al. And this eventually ended up in the blog, the WordPress blog. it doesn't mean there's a problem. I mean, families document. Especially when somebody is ill, it wouldn't be strange to see a family that documented the experience, the treatment, the care, what it was like living like that. These might be precious moments, and just living this together could be therapeutic.
It uses the double negative, but it looks like the statement was admitted. We hold that unless the declarant was not mentally competent when he made the statement, it should have been admitted under the so-called residual exception to the hearsay rule.
I don't believe Florida has the residual exception to the hearsay rule. So I don't think that piece is applicable.
We don't have a residual exception rule.
What? I don't see how this case is any applicable.
I'm not sure that case particularly.
Well, I'm not even sure it.
Would this be 403? Would this be prejudicial? Overly prejudicial? Or would this be extremely probative? I don't know which one it is.
Okay, the decedent in that case was Jesse Huff. So the decedent was Jesse Huff. The PR was Helen Huff, the wife.
Judge is talking about case law here.
Declarant, defendant offered and trial court excluded the testimony of Melvin Miles. So the declarant,
Judge is putting the pieces
who was
together.
the husband of Mrs. Huff's husband and a friend.
He's reviewing a precedent. Yep.
Huff gave the following description of how the accident occurred. So this is a person who heard the decedent say how the accident occurred.
Okay, but there can be some parallels between that letter and this.
Apparently, Indiana doesn't accept privity. So, even if that were the case, you would still run into the problem under Florida law 18D, which is a statement by the party's agent or servant concerning a matter. Mom is perhaps the agent. So I don't see how that case applies at all.
Is the court saying that the audit here is the agent of Maya? Is that what's being...
Well, I mean, the reality is we have... I'm sorry?
Shapiro has case law.
Well, give me a Florida case that's better than a Seventh Circuit federal case.
It's a second district case, 185 Southern 2nd 7.
Shapiro has
Ritter versus
Florida law.
Brengle, Brengle.
Yes, and about 2/3 of the way down, it says admissions against interest made by a person since deceased may be introduced against a person claiming under its succession to the deceased declarant. And then it cites a Florida Supreme Court decision from 1951.
Can you give us the site again?
Yes, sir. It's
185 Southern 2nd 7.
Thank you.
Okay, so that seems to be strongly in favor of
Okay,
the
so
Senate coming in.
I conclude that there is an exception to the hearsay rule that would apply for exhibit
Understanding, I want to put one more thing on the record, which is that we'd object on relevance and 403 because this email is not relevant to our medical malpractice claim. There's no claim back against Proffer against Dr. Cantu. The hospital had no knowledge of this when they did what they did, so it's not relevant to anything that happened inside that hospital for 3.5 months.
Your Honor, they've put central to this case the idea that the hospital had no basis to conclude that there was medical child abuse, that there's no basis for the transfer orders questioning this treatment. It's absolutely false that the hospital did not know about this, because part of what the hospital had and saw in its records were specifically treatments of this. Mrs. Kowalski was in the ER demanding that, Maya be put into a ketamine coma. The plaintiffs have set up in front of this jury arguments that, it wasn't really that high risk, it wasn't that big of a deal. This details, frankly, without using hyperbole, the horror of what went on with Maya in this coma. So it's highly relevant to issues that the plaintiff has introduced.
Well, let's go back to the 30,000-foot view. There's evidence before this jury that there was a 50-50 chance of death that was told to the family, including Maya. We have Dr. Cantu said, well, we say that, but he doesn't believe that to be an accurate. This tells us what happened in, or could be seen by the jury as what happened during day one of the medical coma. There was evidence that was presented to the jury about the coma. There was videos. There was discussion about some lab work. I think there was some discussion that there was some difficulty during the procedure.
Yes, so, recognizing all of that, Your Honor, the only thing that the hospital had knowledge of at the time is what was in their records. And that was a couple of lab results from Dr. Cantu. In order for this to be relevant, there would have to be either a Fabre claim against Dr. Cantu, of which there's no basis for that. They don't have an expert to even opine on causation in that regard. And nothing that the hospital did can be explained by what's contained in this email, because they did not know of it until 3 years into this litigation. So what they did in the fall of 2016 is unrelated to an email that's produced to them in 2019, 2020.
What are we doing about Fabre? Because Mr. Altenburn suggested that there was going to be no Fabre, or potentially no Fabre request.
That's likely the way this is going, but that's not what we're introducing this.
Okay, help me understand what you're introducing.
Okay. Again, Your Honor, they have represented to this jury that all of the medical treatment that the Kowalski sought was completely normal standard of care, and the people at All Children's are not RSD specialists, and they did not understand that what was being requested here was just everyday thing. And of course there was, I had to push for the 50-50 admission because people were downplaying it. What this shows as a play-by-play, because the records we requested from Dr. Cantu were either destroyed or lost or whatever, it shows a couple things. It shows the horror that went on to Maya Kowalski while she was in this coma. It shows that our experts are correct, that this is completely unnecessary and dangerous risk, which just goes directly to the heart of our defense team. It also shows Maya Kowalski writing as if she's Maya, and the plaintiffs have made a big deal about the lack of basis of any Munchausen by proxy diagnoses. This is in the file of Sally Smith as part of her WordPress blogs. It's also, I believe, referenced in Dr. Lewis's report. This goes right to the heart of everything that we're defending against, as the plaintiffs are putting on a case of, we were just seeking conventional treatments that you just weren't used to, and the ketamine coma was no big deal. We can't defend our case if we can't show exactly what Beata was writing in real time It's an admission by a party to the point that's relevant, and this has to come in order for us to defend ourselves.
Well, let's walk through the counts. Doesn't go to false imprisonment, right?
It does not go to false imprisonment.
Doesn't go to battery.
Well, it can go to, well, anyway. It would only go to false imprisonment to the extent that it corroborates what our doctors were trying to tell Beata and Jack Kowalski with, look, we'd like to talk to you about staying here because the treatments that you want, and there's no question in the record that they were coming into the ER saying, we want to put Maya in a ketamine coma. And our doctors, as they testified, the nurses were shocked by this. And this corroborates what our doctors and our nurses were saying, which was this treatment that you're asking for is insane, so let's sit down, let's talk, let's have a real conversation, let's have you agree to the treatment plan. So this email corroborates exactly why our doctors had this thought. So it can go to that.
Not sure I agree with the stretch there, but okay. Doesn't go to battery.
Does not go to battery.
I know that DV is under advisement relative to Maya for negligent infliction of emotional distress, but doesn't seem to go there, right? How about medical malpractice?
Yes, it definitely goes to medical malpractice.
Well, let me ask this, because medical malpractice focuses on the acts or omissions that occurred at Johns Hopkins Children's Hospital.
And whether we were right, and whether we were, because their whole claim, their whole basis, which we think obviously we disagree with, but their whole claim is you stopped the standard of care treatment that Maya Kowalski needed, and as a result of this, now Maya Kowalski somehow, because you wouldn't give her the proper treatment, Maya Kowalski somehow is somehow worse off with relapses and remissions going into the future in a $20, $30, $50, $80 million care plan. Our point is, and as we've said over and over again, the treatment for CRPS is physical therapy, occupational therapy, cognitive behavioral therapy, and time. And you don't do ketamine drips and ketamine infusions at 23 milligrams per kilogram per hour. You don't go for ketamine comas. You don't go for intrathecal pain pumps, which is what they're saying that we prevented them from doing. And this email is the best evidence, and frankly the only evidence that we have to show exactly why we are the standard of care, and this is risky and dangerous. It comes from Beata's own words.
But
and we didn't aggravate. They're going to argue in the jury instructions that we aggravated her CRPS by not giving her this.
But it's true the Johns Hopkins Children's Hospital did not have access to this email, and I'm presuming what's going to follow.
Not true. We had access to it because it was part of Sally Smith's file. Indeed, the WordPress blogs are part of her file.
Well, so now we're adopting Sally Smith as our agent for purposes of treatment and standard of care at the hospital, if we're going there.
Great.
Sorry.
Go ahead.
None of our experts have testified, none of our standard of care experts testified that the breach of the standard of care was failure to give a ketamine coma. What Beata Kowalski, you heard this from Dr. Botter, what she came in asking for was 1,500 milligrams of ketamine, like Dr. Hanna was giving the United States. This reference to 23 milligrams per kilogram per hour is not a reference to this. It's a reference to Dr. Hanna's treatment 2 days before her admission.
Why don't I see, because I'm assuming what I do on day one is going to be what I do on the balance. So let me look at the next few, and then I'll probably take it under advisement and let you know on Monday. But 3145, please.
The Fabre issue is comes from a 1993 Florida Supreme Court case, Fabre versus Myron. It's specific just to Florida. It's one of those precedents that sort of it takes the name of one of the party participants, but it's sort of a rule that's been decided in Florida alone. It can reduce how much money the defendants will owe to the plaintiff based on percentages of responsibility. So the judge is expanding this now. He wants to look at, I believe, more of the WordPress blog and sort of rule on it collectively instead of individually from piece to piece.
Anything that we haven't already said with respect to day 1 with this day 2 email?
Well, again, I also want to point out that Beata Kowalski is writing as if she's Maya, and they have squarely put in front of this jury that we would never agree to these transfer codes because one of the diagnoses is on there, and Dr. Newberger was read into the record saying that diagnosis was medical malpractice. They're going to argue this. This goes directly to the suspicion of Munchausen by proxy as a mother writing as her daughter. So it also goes to that in addition to the prior statements.
But at the same time,
it cannot go to a suspicion of Munchausen by proxy in 2016, October 7th through the 20th of 2016, when it was not in their possession. It wasn't known to them. What she wrote with respect to thank you God and appreciate it Jesus has nothing to do with a Munchausen by proxy inside that hospital in 2016 because they didn't have it.
We did have it.
But beyond that.
Well, you didn't have it for the false imprisonment time period at issue.
But we had it during the time that we were trying to transfer the child.
And diagnose it. Before October 17th?
They would need some evidence in the record of this.
When the transfer attempts were trying to go to Nemours in November, and the plaintiffs keep saying...
Well, time out. You said it goes to false imprisonment. You got the picture taking and you got the EEG. So the only time the false imprisonment is that first week. So that's the point I think Mr. Whitney was making, that it wasn't available for false imprisonment. It might go to your med mal,
yes,
but that's probably the only place that arguably it might go to. So all I want to do at this point is let me see the rest of them. If there's anything unique about the next series, let me know, but let's not have a continued re-argument because I'm not going to rule today.
Yes, sir.
So let me see the day 3, which is 3146.
Okay, so we're looking at each of the emails she sends for each day of the medical coma. I'll let you get a screenshot here. Might have to pause for that. But, this can't really... Yes, it's a little weird. It's a little different. But you're literally writing as if you're in a coma. Okay, so anyone who reads this knows that this is not Maya writing this. Maya's in a coma, and she's journaling her experience. It's different, but interesting.
Let's go to the next one, which is 3147.
Megs, welcome to the gallery. Thank you so much. Appreciate having you as a new member. If I were the horse, I'd die already. Lots of riders on these horses. The judge said he was going to crack down and has tried a little bit. But, man, you've got to hand it to Mr. Whitney, who's pretty much solo riding on the plaintiff side, and defense is almost in full force. It's 1 versus 3 here tonight. Amy, they're saying that it goes towards the MVP because it was in the file for the what's it? The social worker who had it?
And is 3148 the last one in this series?
I believe so.
And it looks like that's 2 pages.
Yes.
Because they found the blog. That's where they got it. They didn't get the emails. They got the emails much later. They found the blog online, the WordPress blog, and that's where they got it from. Today's my last day of coma. It's time to wake up. If you look at this as the mom writing letters to... If she was writing this to Maya, if Beata was writing this to Maya so that Maya would know what happened, does that make it less weird?
I would add one more basis when you're done, Your Honor.
Mr. Anderson's eating birthday cake right now with his daughter. And then probably watching this. Texting furiously. Mr. Hughes has just given Mr. Shapiro one more argument to support their cause. It looks like Ms. Cruels has done the same. No, the judge almost admitted it, and then sort of backed up a little bit.
It goes to show that my clients were correct about the reasons why ketamine is not an effective drug. It's showing, this specific one is showing that Maya is not recovering from these ketamine doses. And we would just submit to Your Honor, just because we believe we can show that my clients, or some of them, had knowledge of this. But even if we didn't, this would be no different than our doctors. Take a simple case. Someone comes into the emergency room and says, I have a broken arm, and we read the x-ray report as negative, and they go home and then they sue us for failing to diagnose the broken arm. Couldn't we say there's an x-ray from 2 days before the admission that is also negative, it doesn't show a broken arm, and sure, we didn't know about that, but it corroborates their diagnosis is the same as our diagnosis. All of this goes to corroborate exactly why, in defense of a medical malpractice claim, my clients were correct. They were correct to be suspicious of ketamine. They were correct to be scared of having Maya undergo these treatments, and it completely contradicts the narrative that the plaintiffs have put in front of the jury.
I'm sorry, what was the end?
Sorry, it completely contradicts the narrative the plaintiffs have put in front of the jury, and it's especially important because, again, the plaintiffs are saying that we aggravated a condition by not providing this treatment.
Anything else, Mr. Whitney?
Their experts are free to come in and testify about standard of care. They don't need this to do so. This, again, was not in their possession, and I'm not sure how it helps them because the photographic and video evidence is that Maya Kowalski and their records, that Maya Kowalski did progressively better and better following this ketamine coma. We would also challenge the idea that they had possession of this information at any time during the relevant 3.5-month admission, unless they're adopting Sally Smith as their agent.
Okay, I'm going to take
it under advisement.
3144, 3145, 3146, 3147, and 3148 under advisement. What's next?
Do you want any additional information for us, Judge, or are you just going to rule?
No, well, let me ask this, and this is bleeding over into a different concept, but since we somewhat referenced it earlier, and it goes to Fabre. Because ultimately, well, I mean, if the defense doesn't seek Fabre, then there's not an issue. But again, the medical malpractice goes to the acts or omissions at the hospital. So following up what Mr. Shapiro was just talking about, let's say you have a car crash, and maybe there's somebody that's negligent in that. It might be helpful to know, hey, there was a crash and what generally happened. But when a person that was a victim of negligence in the car crash goes to the hospital for care and then the hospital malpractices, you don't really go back and apportion the first crash. And so it would seem like from an evidentiary standpoint, it might be helpful to know what happened, but then you don't try to figure out, well, driver 1 was 18% at fault while driver 2 was 83% at fault, because that wouldn't really matter for the malpractice case.
I understand the court saying that typically who caused the car crash doesn't come into whether or not the doctor's malpractice. Is that your point when you got into the ER? Yeah, but again, given this is a very unusual case, and given this scenario that the jury has been presented, this type of evidence specifically goes to rebut their position that our failure to give her ketamine, which is their position, that we stopped the ketamine protocol, aggravated her CRPS to the tune of a permanent aggravation.
But let's be specific. Ketamine in the amount that was given in Mexico is different than a lesser dose. And this jury's already been told multiple times that the dosage of ketamine in the amount that occurred in Mexico is not available in the United States. So,
because this, let me give you an example. Mr. Tremp took the witness stand. This is also why this is relevant. Mr. Tremp took the witness stand, and it was memorable. I'm sure you remember because we got into it. She was a freight train heading to college. This ketamine was all working, and because you didn't give her the ketamine, she's now a wreck and can never do X, Y, and Z. These records go exactly to my cross-examination of Mr. Tremp, and the jury needs to see them because the only picture they've gotten from the plaintiff is, and especially with their expert relying on it, from everything I've seen, Maya Kowalski was happy, healthy, and thriving with ketamine. These words from Beata, a first-hand witness to what exactly was happening to Maya during ketamine comas, is essential for the defense to be able to rebut the information that Mr. Tremp is showing that this freight train heading to college was actually near death on a table in Mexico because of the treatments that they put her through then, and they continue to advocate in even higher doses at Dr. Hanna's office. And that's exactly the point. I mean, he was giving 3 to 7 milligrams per kilogram per hour in an intubated session. Dr. Hanna was giving 23 milligrams per kilogram per hour, and we need these records to be able to say that this is what ketamine does to somebody, not this rosy picture of what the plaintiffs are showing. You get a couple doses of ketamine and then you're swimming in the pool. And they're asking for over $5 million in ketamine as a reasonable, as a necessary treatment, and we need these to be able to tell the jury, no, this is what ketamine does to a child. So it goes to damages, it goes to medical malpractice, it goes to aggravation, it goes to state of mind, it goes to a number of relevant issues.
and I said I will take it under advisement. I in a moment, but I continue to struggle. I feel like we're almost on a collateral issue.
I understand where Your Honor says, to us it's the heart of the case. That's all I can tell you.
Just on this point about this being relevant to Mr. Tremp's testimony. Specifically, the $5 million in ketamine that Mr. Shapiro just referenced is not for recurrent ketamine comas. It was for the infusion treatments at Dr. Kirkpatrick's office. The same type of treatments she was receiving in the United States immediately before the hospitalization. So what's relevant is the demand or request of Beata and Jack to have a similar dose that Dr. Hanna was giving. Nothing about a ketamine coma and what transpired there. And again, there's no file break claim against Dr. Cantu.
Let's move on. What's next?
Judge's not going to rule on that right now. That'll come later at any time during
3149.
During the proceedings, obviously before those letters come in.
There's actually 12 of them. It's her advising Dr. Kirkpatrick of...
Isn't this similar to the one that we just ruled on?
Yes.
Yes.
I think we're...
The terminally ill stuff, you've...
No, I don't think it's...
It is terminally ill.
It is.
Right at the bottom.
Okay.
It's just a different copy of the email.
Oh, yes.
This one's printed in color with emojis.
That's the only difference. Revisit that on Proffer.
Yes. 3150. Oh, we must have skipped one, Judge. This is coma day 6. Somehow it got...
Let me just see it.
Yeah.
Let's not have any argument on it. And
Right.
It'll be taken under advisement.
Yeah, I just think we... Yes, this belongs in that same grouping, Judge.
3151, Clay. Thank you.
Day 6 was a good day.
No, I think that's day 6, so that's
Day 7, ketamine infusion was stopped at 10 a.m. or before
Is this
day
still
7.
3150?
Yeah, there's a few of these that were ordered.
Wonder what will be my favorite drink when I wake up from coma.
There's several more, Your Honor, not to interrupt you, but if we're going to group them all together, we can show you the next ones in the series.
Yeah, let me. I have finished 3150. Show me the next one.
3151.
Despite fatigue, it's been so nice to not feel pain. I was sore, but don't feel the horrific RSD pain. Thank you. I was so happy to have Mommy and Daddy here with me. Seemed like a happy ending to a long nightmare. The morning was really happy for me, but then I got a headache around 10 a.m., which shortly turned into a migraine. Then my back started to ache more, most likely
What's next?
DT, like coma for 7 days. First of all, I'd like to tell everyone that I'm getting better. I'm just taking baby steps. My biggest problem at this point, I'm jumping down. Oh, now it's gone. Guess I have to read much faster than I am. These are more blog entry style emails from Beata. Gotta read really fast. Gonna have to practice all night.
3153.
Says I'm sort of handicapped in a wheelchair. I'm the last one to get off the plane, but the first one on. Houston Airport is humongous. I got off on the totally opposite side where I was supposed to catch the next flight. First I had to, and then sent. It's like she started writing and then just sent what she had.
I mean, this one doesn't seem to discuss anything about medical, so
We'll agree.
3153 will be out.
3154.
This looks like the same email.
Oh, I apologize. Is it 3155?
So 3154 is out as well.
Sorry, I think 3153 was the one that I misstated. Clay, will you go back to 3153? Oh, sorry, 3153 and 3154 are the same.
Yeah.
Okay, so 3153 and 3154.
Okay, so the transcript's clear. 3153 and 3154 are not admitted.
3155 relate to the ketamine boosters.
Peter, thank you. Gifted 5 memberships. Thank you very much. It's very generous of you.
Rich, do you want hard copies of these?
Yes, please.
Yes?
Yeah, if I can take them home tonight.
Okay.
Judge puts in the long hours. He's going to be doing some homework.
Just query, how is it possible if Beata Kowalski's in the United States and this is happening in Mexico, how is this possible?
Email works.
Well, assuming that this is Beata, and I think that's what we were working on, I flew to Monterey Saturday the 19th, and on Sunday the 20th I got admitted, and it's talking about specifics.
I think that goes to our concern over the reliability of all of these emails, Your Honor.
Well, I think she emailed from Mexico, isn't it?
Well, it says Mommy couldn't switch her clients and couldn't get the time off from work. So Daddy had to fill in Mommy's shoes.
But there's still statements by the decedent which are chargeable against the party. It's still Mom's recollection and statements of what went on with these comas and these boosters, which again,
Well, how can mom make a statement if she's not there? I mean, just practically, how's that possible?
The other reason we would admit him again is I think it goes to the state of mind and the potential Munchausen's diagnosis that they criticize with mom logging as if she's not.
What's the next one?
Which one was this, Clay? 3156.
It's dated 12/22/15. Can't you give me another high ketamine booster, 500 milligrams over 2-3 hours? If these are coming in, the plaintiff has got to be able to explain them to the jury a little bit, because as most of us sit here and look at these,
Well,
a lot of us say this is a little
this
strange.
refers to mommy being in the United States while all this stuff's happening in Mexico.
Yep. I'll just be heard on this one last time again.
If it's duplicative of what you've already said, then no. If it's something new, then okay. Is it anything new?
I think I've already made the point about the Munchausen diagnosis.
Yeah.
Okay.
Okay.
No, and for the sake of expediency, Your Honor, there's about 30 of these. Do you want them all printed out and given to you rather than going through them one by one? It's up to you.
Judge,
Yeah,
like
that's probably
30.
better.
I just don't want to keep you regulated. And
There went his weekend.
Many of those that are to come, Judge, are not in Mexico. They are stateside, and they're monthly updates that provide the foundation and baseline leading up to the 2016 admission issue.
So these, Mr. Hughes says there are 30 of these.
And so
Many
you'll
of
be
them
able
are
to
written
print those out in a few
stateside
minutes here?
monthly updates about her condition.
Okay, so let's go on to the next one that is not in this series.
Yeah,
that
I'm trying to figure that out, Judge.
Steffi has a good point. Writing as Maya is literally by proxy. Doesn't look mentally well.
just, Clay, will you print them all the way through 3181? Does that make sense to print? You have to
The Winslow Wonder says, it may seem odd, but my mom did similar things as a coping mechanism when I was born. I had a lot of complications at birth, and mom wrote journals in my voice.
I'm just looking at your list here. It looks like 3172 might be different type of thing.
We'll pull it if it is.
I'm just saying we might want to address it now.
Okay, sure.
Something tells me there was another judge at the very beginning, if I remember correctly, but this one's been here for quite a while, I think.
I know you're printing. Can you
Maybe
also pull up 31?
Amber, could you confirm that for me?
or Mr. Reyes could also probably pull up exhibits.
We have it up, Judge.
All right.
This is from Anthony Kirkpatrick to Anthony Kirkpatrick. Effects of ketamine on the developing brain, and here they've withdrawn it.
Scratch all that.
We want it. We'll take it. Admit.
Withdrawn.
The plaintiff says, wait, that's good. That's
So
good for us. We'll take it.
3172 has been withdrawn by the
That's correct, Your Honor.
defendant. What's next?
I've got a link in place for Rob's wrap up tonight.
I think
This is recap.
3175 is also
So when this
perhaps
ends, we're going to
not
portal people over that
part of the
direction.
series.
Hey, can you tell 3175?
I will be a little bit torn because I have my own podcast that I do tonight that'll probably overlap that. So I'll have to be on sort of replay for the
Oh, I'm sorry. It
for
says
Rob's
on
wrap
your
up. But
sheet here between Biad and Dr. Cantu.
Yeah, just say that as
It's chaotic or self. It should be
Well,
opposite.
maybe try 3176 because that also has.
Okay. This looks like an email with Dr. Cantu. Oh, yeah. This one. Is that it? I think Has already been shown.
We had a discussion about it because the judge.
Madam Clerk, is 3176 in evidence? Clerk says it's not.
Well, there might be a corresponding 2,000.
Let's get it in. Sure.
Yeah, I recall this being discussed. Maybe I just looked at it, but Dr. Cantor was testifying, Judge.
Your Honor, astutely noted that everywhere else in the world orders their days and months differently in the United States.
Yeah.
Mr. Hughes is talking about the
I
fact
agree with
that
Ms.
the day
Pearls.
month.
I think we've had a conversation.
This was January 6th,
I
not
think it's in his
6-1.
2415, Your Honor.
2415?
It is, okay.
Can you just pull up 2415 on one side and 3176 on the other side?
Yeah, it looks the same.
Okay, so
Goalie Mom, thanks so much for being here.
2415, let's just make sure that's in. Clerk is saying yes, so we don't need 3176?
Yes.
Okay. There we go. So we don't need to do anything with 3176 because it's already in at 2415.
Take the victory. Okay. Just trying to look at the descriptions here, Judge, to see is clinically.
So this is a surprise time to get evidence in, but it's been very effective.
I think we've looked at these already, and I'm not sure. I have to go back and look, Judge, if we've already visited these and the court has ruled or not. I don't want to repeat myself.
This is from Lindsay, or from the last witness,
Okay, what about 3191?
to Cynthia
See that one, please?
Zangart. From Beata to Dr. Kirkpatrick. Begin forwarded message from Deborah Salisbury.
No,
Ooh.
we'll take it. No, we'll withdraw this.
Take that bond paragraph in isolation.
So
why are they?
One was just withdrawn.
Yeah, well,
What-
Judge, I think we need to look at. I'm sorry.
What number was just withdrawn?
3191, Your Honor.
What's next?
3240.
The deposition of the last doctor is on
Daisy
hold.
Award.
Yes, Your Honor.
That's already been talked about. Okay, put up 3240.
They're cutting out big chunks of plaintiff designated time. This is the Daisy Award from Maya for one of her nurses. Daisy
Any
Award's a
objection?
big thing.
No, Your Honor.
3240 is in. Is received, I should say. What's next?
Judge, I think that's all we can address without.
We're going to go back through these, and if there's any more, we'll let you know, but I think that's going to be almost everything we're going to try to.
Well, we're going to have Kathy Beatty emails, but I have to go through them.
Well, let me just, my understanding was this was supposed to be a relatively comprehensive list.
I'm sorry.
So next week, we're not going to expect lots of new exhibits that are not on this.
Well, I think, Judge, the Kathy Beatty emails are 800 pages, and I need to go through that. Not the one that's listed here. That's a different one.
She said Kathy Beatty email is 800
Look at that
pages.
one. But then there's literally 800 of them. I need to go through this weekend and distill which of those I'm going, based on the court's rulings to date, which ones I'm going to try to get in. So there will be some. She's not testifying Monday or Tuesday, so we can deal with that with the court's indulgence on that. I think that's pretty much it.
Yeah, because the rest were WordPress blogs, but I think that WordPress blogs are verified by the underlying emails that you're taking under advisement. Your Honor is concerned about the WordPress blogs were authenticity. So if you're going to let in the underlying emails, that's going to answer our question, or vice versa. So.
And just so you're aware, too, Your Honor, the WordPress blog is effectively stops in December of 2015, so a lot of the emails, the tranche you're getting into 2016 would not be in the blog itself.
I just want to, because we've got time, if there's other exhibits, I don't want to miss an opportunity and make us stay late another day.
Well, let me look.
I think the attorneys were going to be here till 6 p.m. today.
Any others that we need to address in the court? Okay. Can you just give us a minute, Judge?
Yes, ma'am.
Thank you.
Hey, Tina, I'll show you the orange hoodie. Hang on 1 second. So I'm going to show you the orange hoodie you're talking about. We have we did the Cavalcante manhunt. We tracked that live on our channel for as long as that went up in PA, and during that we made a new item of merchandise, which was a hoodie, an orange hoodie, and it says I'm going to have my son grab mine. But I got one for myself. It's going to be my Halloween costume. This is about the level of effort I put into a Halloween costume. But I'll show you here in just 1 second. Here we go. So the front says, this is my prison escape hoodie, and on the back, this is why I was never hired by Victoria's Secret to be a model. There's probably another reason as well, but on the back it has the Recovery Addict and then the courthouses for our member colors across the back. Which is funny because the green one disappears, and I think you see the courthouse through there. But anyway, those are the orange hoodies we're talking about. We are giving away a hoodie to the winner who gets the closest on the total objections. And just for the record, I think I've missed a couple, and I'm sorry about that. If you guys can count and tell me, I'll correct it. But let's see, Rudy Patootie, Epic Exposure, who's now known as Pickles the Cat in chat because you got stuck with a name change. Dodie Sweeney. Lots of people at 1,200. We went through a few people here. Crystal, Dr. Jennifer. Oh, here we go. Dr. Jennifer, we just passed you. We're up to Jill Ballard, and Majestic Unicorn, Dr. Sue. That's where we are in the list, and we have a ways to go. What scale would you put Maya's case when it comes to the jury? Right now, I'd say 75%. Maya, it was 90%. We'll probably go down some more. Hopefully not much. What scale would you put Maya's case? I missed something on that, P. Will, for real. I'm not sure if a word got dropped out of there, or maybe I failed at reading. What scale would you put Maya's case when it comes to the jury? As far as where the jury lands right now, I do think they lean towards Maya right now.
You go back to flying fighter jets. How about that?
So you basically are saying that today, because of the testimony, you're leaning closer to defense.
3225.
Or more so to defense. Likely the chances of winning.
Are these on the list?
Yeah. No, they're not. I'm sorry. We're back. I think that one's in.
No objection.
I don't remember seeing this one.
No objection.
Now, all of the metadata that's under there, is that?
We can get that removed, Judge. But we need the date, though.
I'm not opposed to it. I just.
We might have to object to the username of Raspberry Shopkins. I don't know if she still uses that.
Well,
and she has quite an Instagram followership these days, but I'm not sure it's Raspberry Shopkins.
Okay.
Well, let's. I try not to put email addresses and telephone numbers.
Go ahead and take it down, Clint.
I'm sorry, I didn't mean to announce.
I'm sorry.
You know what? Before we start flashing stuff on the screen, we'll go through them. We have other things we can discuss rather than.
Yeah.
Thank you.
I didn't realize we were publicly putting that up. Sorry.
So Instagram just she got a few more followers.
Yeah, 3168, Judge.
3168.
It's out there now.
This is in March of 2016. Beato writing to the church requesting this information be put in a flyer for a fundraiser.
Trying to show you a few more. Is that too fast to read?
Seeking money for more ketamine booster infusions.
There you go. That gives you what's coming up next. We'll probably get that far later on. Did Sally Smith testify? I think Sally Smith and Beatty both testified by deposition. I think Sally Smith may be coming in person, probably towards
We object, Your Honor.
as soon as the plaintiff runs out of time.
The redactions there are prejudicial, and the idea that she's doing this for financial gain is what the defense wants to get at. So there's no way to do this. Well, part of the Munchausen diagnosis or theory is that a parent's doing this for ulterior motive. So they want to argue that Beata Kowalski is putting her daughter through all of this because she can make a few $1,000s. The redactions under that last paragraph says begins currently. You can see two redactions, which would be insurance companies. And so, yeah, it's expensive, but the reason she's seeking money is because insurance doesn't cover the treatments. So I don't know how you can extract that and then make an accusation against the mother that she's doing this all for financial gain.
I just had a clarification. Are the plaintiffs alleging in this case that we misdiagnosed Munchausen or no?
Well, let me ask you this. Is the hospital contending that mom had Munchausen?
Well, the diagnosis code that we have to defend says one of the reasons for transfer, it's in the diagnosis. So it's one of the diagnoses. Are the plaintiffs alleging that that's a misdiagnosis?
Because I've been unclear as to whether the defense agrees that whether she does or does not have CRPS.
The defense of this case from a medical malpractice standpoint is that whether this was psychological, RSD, conversion disorder, Munchausen's by proxy, the treatment would be the same: physical therapy, cognitive therapy, occupational therapy. What I'm asking the plaintiff is the plaintiff alleging that the Munchausen diagnosis was wrong, that we committed medical malpractice by having that appear in our record, that we committed medical malpractice by having that on the transfer code, that it goes to that because of that allegation that pushed Beata to some type of intentional infliction of emotional distress. If they are, then we absolutely need not just these that I'm going to hand to court, but these things of fundraising, because it does go to that diagnosis. So the answer to Your Honor's question is we don't plan on making this case about whether she had, which disorder they had, but we definitely, if the plaintiff is going to allege, which I think they have, clearly, that the diagnosis of Munchausen inflicted distress, stopped transfers to the Moors, was a medical malpractice diagnosis, then this would go to our defense to say that that diagnosis was one of the working diagnoses on the district.
Yeah, I'm unclear.
Okay.
Because I go back to opening statement, and Mr. Hunter made a statement to the jury to the effect of, we did not have to be right, we only had to be reasonable.
Correct.
Which I thought was an interesting statement at the time. But I'm unclear now by what you're saying whether the hospital agrees that Maya Kowalski has CRPS. Because, I just heard a whole bunch of depositions today that seems to suggest that the hospital is saying she doesn't have CRPS.
The hospital's position on this, and from the defense's point, is very clear. The diagnosis of CRPS is questionable. Whether she has it or not is subject to debate because there's no test to rule it in. There's no test to rule it out. It's a syndrome. It's not like you can take a blood test and say that you have CRPS the way you could say you have leukemia. But from all children's point of view, whether she had CRPS, whether she had psychosomatic pain, conversion disorder, or whatever the new language was that you heard from the doctor, the medical treatment for this is the same: cognitive behavioral therapy, physical therapy, occupational therapy, all of which we provided, and all of which, to the extent we could not provide, we were trying to transfer to other institutions that had a higher level of care for this. Yeah, I think that you can see in the discharge, if it's on the admission diagnosis, we provided treatment for her if she would have had it. It's also on the discharge. CRPS is on the discharge diagnosis as a can't rule out. So the hospital's position on this, I don't think should not be unclear to this court or to this jury. We are not taking the position that Maya never had CRPS. It was a diagnosis that we considered, we respected, we provided treatment for, just the same as if she had a psychosomatic disorder. And on the discharge diagnosis, it says it couldn't be ruled out. So if that answers the court's specific question about what our position is on CRPS. There's just not a blood test for this that we can say, yes, she had it, or no, she had it.
I heard what you're saying. I'm not sure I think it's a clear answer, but I hear and I appreciate the line you seem to be trying to walk. But I'm not sure I totally understand it being a clear answer.
I'll try to give it to you in 10 seconds. To the pain management team, it didn't matter. The treatment for, and Dr. Elliott has testified to this, our pain management team testified to it. I think the ICU doctors, I thought, testified to it, but our pain management people will testify to this. The treatment for RSD/CRPS is exactly the same treatment as cognitive behavior, as conversion disorder or any psychosomatic, or I think it was called central sensitization disease. It's cognitive, physical, occupational therapy. And to the all children's team, it didn't matter whether she had CRPS or not.
Well, then my question back is, does it matter whether mom had Munchausen? Because one, Johns Hopkins Children's Hospital is taking the position that it's in a children's hospital, it's not an adult hospital. It did not seek to provide any care and treatment. There's certainly evidence that's been adduced that this is a diagnosis that would impact Beata. Frankly, I'm struggling to see how it goes to what type of care for CRPS that the hospital did or did not provide to Maya, and the focus is on Maya for medical malpractice. So that, I'm struggling with why we're spending so much time on it when it doesn't seem to be an actual issue in the case.
Only because the plaintiff has injected this into the case, saying that your diagnosis of Munchausen by proxy or as a reason for the transfer is the reason we couldn't accept the transfer, and it was a negligent diagnosis. Your diagnosis of Munchausen by proxy caused intentional...
Time out.
Correct me if I'm wrong, but I don't think the basis of medical malpractice is the diagnosis that precluded a transfer. Is that, am I misunderstanding the case?
That specific question, whether the listing of Munchausen by proxy on a transfer diagnosis is not the basis for a malpractice claim, that was first an issue raised in this case by the defense when they attempted to claim that effectively Jack and Beata had been unreasonable for not accepting that psychiatric diagnosis in that transfer, and it was on them for not accepting the transfer to Nemours. Then we get testimony that Nemours doesn't in fact have a CRPS inpatient program, and Ms. Beatty lied on the phone to Beata Kowalski, and it was a psychiatric diagnosis they were trying to transfer her for.
Let me stop you because I need to understand it. Is the plaintiff saying that there was negligence on the part of the hospital having to do with having that diagnosis, the conversion/Munchausen?
This is going to affect what documents he allows in.
Medical negligence on failure to transfer.
I just want to rephrase the question to make sure I'm understanding. Is our position that it was a breach of the standard of care to use Munchausen in the transfer diagnosis? Did I understand that correctly?
Are you claiming any sort of damages? Let's do it this way. Sure. Any sort of damages associated with a non-transfer that occurred on whatever date that was or that time period.
When was if he says yes, the documents come in. If he says yes here.
It was in November, and I would only, if I may, Your Honor, I would even broaden that to ask the plaintiff, are they seeking any damages from this defense for the diagnosis of Munchausen by proxy? If they're not,
if he says yes to that, the blog comes in.
Well, I'm going to try to answer the court's question first. I don't believe we're allowed to seek damages from the transfer attempt in the context of a Chapter 39 proceeding. I think that was a defense theory raised to muddy up the false imprisonment claim, and now I'm hearing that this transfer diagnosis or transfer attempt wasn't even made until the middle of the dependency proceeding when Chapter 39 shelter order was in place. So I'm sorry.
No, go ahead.
With respect to Munchausen by proxy, I think the court a second ago spotted the issue, which is that's a diagnosis of the mom. So they take a position that's duplicitous. That is in their records, Munchausen by proxy. There's no question. But then they retreat and say, well, we're a pediatric hospital. We can't treat or diagnose adults. But yet their records of Maya Kowalski are littered with an adult diagnosis. We have been asking the question for years, and this is what you're hearing. We can't even get a frank admission as to whether or not CRPS was or was not a diagnosis of the hospital they were treating. We've tried innumerable times. They won't commit to what their diagnosis was. And then to take the position that the treatments for all of these conditions are identical, well, that's preposterous. But secondly, if that's true, our breach of standard of care, Dr. Duncan testified to this. If you're taking the position that all of these conditions, no matter what they are, require cognitive behavioral therapy, and you provide 3 hours of cognitive behavioral therapy over the course of a 3.5-month admission, we can go with that for the moment, and it's a breach of the standard of care no matter what diagnosis they ultimately land on, but they won't land on one.
Well, with respect to the first attempt transfer, the one in October that occurred during the period of time for the claim of false imprisonment, it seems to me whether mom had Munchausen or not is not the issue. Because the evidence, the issue is mom didn't want to sign the form because of that diagnosis. So even if the plaintiffs, or even if the defense said, well, mom had Munchausen, that doesn't change the fact that mom wasn't going to sign the form. And so that doesn't go to the question of
Mr. Hughes.
False imprisonment.
No.
Right. The form
so how does it go to Maya's medical malpractice claim or any claim that's actually remaining in this case?
Okay. Everybody hop on the horse. Let's ride it around one more time.
The transfer attempt was in November, but I would just reiterate this.
The first one was October.
The first one was October. The form was for a November transfer.
Okay.
But all that being said, I think I see exactly what the court's question is. So I would ask it again. Are the plaintiffs seeking damages from my client for any of the counts for what they're alleging is a miss or a false diagnosis of Munchausen by proxy? If they're not, if we have a stipulation from the plaintiff, we're not seeking damages from you for the diagnosis of Munchausen by proxy, then I don't have to put on a case about why that diagnosis was correct. So I turn to the plaintiff and ask them that again.
What I want is I want the defense team to huddle inclusive of Mr. Hunter and the plaintiff's team to huddle inclusive of Mr. Anderson. I want you all to talk about this issue. It's both what Mr. Shapiro was just saying, but I also think it goes to the question of whether the hospital is going to contend or not that Maya has CRPS. Because I mean, I hear what you're trying to say, but sitting here, it doesn't seem to come across pretty clear as far as the evidence that you're presenting. If we get to the point where there's an agreement as to the plaintiffs are not seeking damages, and I'm not saying that they have a valid claim, but for this exercise, if they're not going to seek it, and you agree that they're not, since they're not seeking it, we don't have to deal with it, it seems like a lot of this issue goes away.
I totally agree.
Mr. Hughes is
totally agree.
Yeah, and he got a bingo too. He said bingo.
Okay, we'll huddle. You need to huddle, and I really want to know on Monday the outcome of it. But I also want to know if the hospital has a more clear statement as to whether my Kowalski has CRPS.
Okay, I thought I announced it, but I'll try to synthesize it.
It might be that you're just going to go with what you went with, and that is what it is.
Okay, thank you, Ron.
We are 4 weeks into the trial, and we don't know what we're fighting.
Let's go back and sharpen our pencils and look at the actual claims that are in this case. And knowing that I've knocked out a whole bunch of claims, both before trial and during this trial.
It goes to the same issue. The remaining documents we have are similar fundraising and things that may not be relevant if the plaintiff is not seeking damages for alleged Munchausen. We probably don't need a lot of these.
So this is probably, even though we're not exactly at 6 o'clock, probably a good time to just say, I think it is. But I actually think this discussion in the last 10 minutes has been helpful. Now, my hope is that the lawyers that are here can go talk to the lawyers that are not here and see if we can come to some sort of agreement.
Yes, we appreciate the court's guidance, Your Honor.
What time on Monday?
Your Honor, may I approach? I have the compendium.
Great, thank you.
Thank you.
What time on Monday do we need to be here, knowing that the jury's going to be ready to go at 9?
Yeah, all of our witnesses on Monday, Your Honor, and I think we've announced them to the plaintiff.
I don't know if we have or not.
Have we told you, Mr. Whitney? Well, I apologize. On Monday, we're going to have Dr. Mendez, Dr. Katzenstein, Dr. Elliott. I think there's a question about Dr. Kriesman appearing.
What about attending by Zoom?
Dr. Kriesman, without getting into why I would need to attend by Zoom, he would come late in the day if we still have time after calling Dr. Mendez, Dr. Katzenstein. Dr. Elliott, to your question, Your Honor, Dr. Mendez's records are small. They've already been admitted to evidence. Katzenstein and Elliott are both all children's providers. We're only relying on their records that are already in evidence. So it's a short way of saying I think 8:30 should be fine for me.
And those two that you just said, whatever their names are going to be here live?
Yes.
All three of them?
All three will be live. And the fourth one, Dr. Kriesman, he's an all children's provider. He would be by Zoom, but again, the same records as just all children's records.
Mr. Whitney, did you get the list down?
Yes.
Okay. So I go back to the question of what time do we need to be here on Monday?
I think 8:30 is fine because we're not looking to introduce any exhibits not on that haven't already been admitted for those witnesses. 8:30.
So we have filed our depositions of the experts that were deposed on the defense side for the court's consideration of our motion. We also still have a motion for a curative instruction that's pending, so maybe we can take that up Monday morning.
The motion on your experts, are those any of the people that are coming on Monday?
No, Your Honor, but if they're filing one against our experts can be coming that week, and so.
Well, my immediate question was what time on Monday, so it sounds like 8:30 is the time we need to be here, 8:30 on
That means we're going to start at
Monday.
8:15.
And I do want to have a report back of what that conversation we were just having the last 10 to 15 minutes, and remind me to address this question for instruction, and then we'll go from there.
There was state
Zoom just ended, so they're about to end.
And I think Clay wanted to address about Zoom. I'll turn the table over to him.
We talked to Mike about it, just with the screen sharing issue. I think Mike figured it out.
I stand corrected.
So there's nothing I need to do?
I don't believe so. On Monday morning that might change, but there's more I can grow.
Everyone have a good weekend. We'll be in recess until Monday morning at 8:30.
Thank you. Have a good weekend, Your Honor.
All right. So with that, they wrap up in court. This is crazy. Seriously, 5 years of legal battles, of powerhouse legal battles, and we don't know what we're fighting over. It's like, wait, what are you contending? What are we saying? Oh my goodness, what's the theory of defense? Okay, how did we get this far and we still haven't covered these basic things? Solo YOLO, first of all, thank you very much for becoming a new member. I appreciate that. You asked the question, Recovery Addict, when you get the chance, can you let us noobs know what your channel covers? Solo YOLO, I'm a bit of a nerd. I love the law. I'm a bit of a true crime addict. I also have some gaming addiction in my past as well. That's when we talk about Recovery Addict. That's more where I'm coming from. We can go into that sometime if you'd like. But and by gaming, I'm talking about computer gaming, not slot machines. I don't have the money for that. Anyway, we cover true crime. So mostly we're following court cases. We often will follow some police chases, other crime-related things. We did follow the Cavalcanti manhunt up in Pennsylvania. That's mostly what we do, and we follow and comment on live trials. We're branching out. We've got equipment to go to courthouses now and streams directly from the courthouse, much like some of the big channels do that. We're looking forward to doing that. So some of the big cases that are coming up, whether it's Brian Koberger, if they allow cameras in that one, that's one I'd like to be in Idaho for on that. We're watching Sarah Boone, which is coming up here shortly here at the end of the year. We've got lots of fun stuff coming up, but that's what we do. This is a very friendly environment. If you came over from Law and Lumber, I think I've never found another community that's quite so closely aligned with what we are here. It's a very respectful channel. We enjoy things. We can have different opinions and share them respectfully. And it's just a fun place. So it's just a group of little friends that wants to stay up to date on true crime. Mostly we do live coverage and of cases, and sometimes they're usually criminal. This is only our second civil trial, civil case that we've followed. But anyway, does that answer your question? Any other questions? I'm happy to answer them. And thank you very much. Let's see. Do you think Law and Lumber would allow you to be a guest tonight? No, I don't think so. Here's what I'll say. Rob and all the rest of LawTube, they're in a different class. They are lawyers, which I do not pretend to be. I love the law. I've liked it since I was a kid. I followed it. I love learning about the law, but I'm not a lawyer, and I'm not giving legal advice. That's not me. I'm a true crime addict and enjoy watching and learning together and learning from other people. So that's where I come from. I'm a bit of the nerd. That's why I've got all the gear and the tech stuff. I look at court cases and I get frustrated when there's an interview in a police station and the suspect sitting there and all we can hear is like noise and I'll take it and I'll run it through a soundboard and I'll get rid of the noise and try to make it better to listen to. So a lot of people will comment that, why can I always hear better on your channel? That's what I do. That's what I bring. Rob, the other guys, all of whether it's Ian, Emily D. Baker, lawyer, you name it, love LawTube. They're incredible at what they offer. I'm not trying to compete with them. I don't have that expertise. I'm not pretending that. So I don't know if we'd ever be a good match that way. But we do cover the same case here. Rob's covering the same trial, and he goes on at night, and I go on there during the day, and it's been a lot of fun to have a little bit of overlap there. And Rob's been beyond gracious. I can't say enough good things about him. Just a genuine, a good guy, and is really helping us out. That said, maybe you could teach Rob how to remove the ridiculous floating heart emojis from the chat roll. Yes, if he wants to, I can show him how to do it. It's a setting; it can be removed even while you're live. It's on the studio page, YouTube studio page. Let's see. So much to take in today, says Laurie. Yes, and tonight, when this is over, we have a portal opened up to go straight to Law and Lumber. So Rob's channel, if you stay on here, you get prompted to make the jump. Rob has that tonight. He's got the recap at 7. Then following the recap, we're going to at 8 o'clock. I have a podcast to do on this channel. I realize Rob's still going to be live. I'm not going to ask you to skip that. But if you'd like to be here for the podcast, it's something completely different. It's lighthearted. It's fun. It's with one of our mods. His name is Thomas. He goes by Weatherwatch in chat. Good friend of mine. And we just take a lighthearted approach to the weekends. And it's about an hour long and just have some fun. It's interactive like this, and it's done live. And so if you want to come see that, we'd welcome you and love to have you here for that. But then after that, I think Rob is scheduled at least. I'm not sure how he's going to do that, but he's scheduled at least to have his Friday Night Frenzy, which I think there should be a fight involved. I'm just saying. Lawn Lumber says 6 p.m. tonight, Sparkles. Is that Eastern time? Or is that Central? That's what I'm asking. Adam says, Adam's a good friend of the channel. Says, Recovery Addict, I'm watching Rob tonight instead because he doesn't tell dad jokes. Occasionally dad jokes get told, maybe frequently, but that's it. All right, Rob is going to do a great job on the recap on this, and I trust you to his capable hands. That being said, it's been a long day. We've had some crazy things happen. It's been wonderful. I can't wait to hear how the current issues that are before the court get decided. We have several DVs that need to happen. There's some motion that the plaintiff has put in. We've got some arguments over expert witnesses that has to be considered, and all this before really we can move too much further into the case. The judge has said he wants some of this done, I think, by the latest Wednesday of next week. So the directed verdict stuff's all going to happen. We're going to see exactly what's going to stay in and what's going to go out. Rob is at 7 p.m. Eastern tonight. Thank you, Magical Mary. Appreciate that. 6 p.m. East, 6 p.m. Central. That makes sense. I'll just talk about what happened in the last 5 minutes. The last 5 minutes blows my mind, Selena. You've got the judge who steps in, and the reason this came about is because we're talking about evidence that the defense wants to put in. And they've brought up these emails that Beata sent that she wrote. It's for her blog in the voice of Maya, describing what she's going through the ketamine coma and beyond. And there's this whole WordPress blog that these ended up on, and that's how the hospital got them. That's how they found out about them. Their investigators, did their homework and found this blog, grabbed those, and then they also subpoenaed the emails that were intended for that, and ended up getting additional emails beyond what the blog covered. So they're trying to admit these into documents, and the plaintiff, Mr. Whitney, on his own with Mr. Anderson gone, is fighting this as every way he possibly can. And he says, we don't want these in. It looks bad because it's a little weird. It's a little strange. Even all of us in chat say, some of us are like, yeah, I can see a little bit, but some of the voice and it does seem just a little strange. And honestly, if you were to look at this in the light from the hospital's allegations where they're saying there's Munchausen by proxy, it does make a little more sense in that light than just on its own. And so the hospital wants it in because it makes Beata look bad, honestly, and it makes her look strange, and it sort of supports their suspicions. But as the judge is weighing this, and he's looking at, he's saying, I'm not sure if I'm going to show me all the letters, and he goes through all the letters and reads them, and he's like, I'm not sure if I'm going to bring this in. The defense makes the argument that we need this because this shows the Beata sort of writing the voice of Maya, and that's how we got on this tangent where eventually the judge says, okay, stop for a second. Are you guys on defense? Is that your issue? Are you saying that this diagnosis of Munchausen by proxy was wrong? Is that, and defense is saying, is that what the plaintiff is sort of alleging, that we got it wrong with the Munchausen by proxy? And Whitney says, we're not Munchausen by proxy, that's a diagnosis of the mother. You guys are at Children's Hospital. And the defense is, it's almost like when you go to, you try to make a deal with somebody, you're trying to barter, and the first person to give out a number loses. This is what we're seeing from the plaintiff and the defense, because they're arguing back and forth, and nobody wants to out their position first, right? Because the other person might give up more ground with their initial offer than the other. So they're sitting there fighting against each other, and it really looks like we don't know what we're fighting over. They do. It's spelled out in the allegation, in the original complaint. It's all there. But when the judge boils it down to this and says, hey, there's this key issue that nobody has addressed, and it has to do with, did the defense, is the plaintiff saying that the defense did wrong in this Munchausen by proxy, and so we're waiting. They're going to talk this over. We're going to see, and it's confusing a little bit because the implications, I think, are bigger than they seem in this. Because if Mr. Whitney were to say, yes, that's what we allege, you're exactly right, that's what we're after, suddenly it changes in the judge's decision. He says, well, if that's what you're alleging, they have the right to fight against that. And suddenly all these emails have a much higher chance of coming in. I would say like 100% chance of coming in. If he says no, then he's going to turn to the defense. Judge will turn to the defense and say, if they're not alleging this Munchausen by proxy, this whole thing, if that's not part of this, why are you trying to prove it? All this can go away. And Mr. Hughes is over there going, yeah, bingo, right on, Judge. That's what we're talking about. So hopefully the two sides can get together over the weekend to talk this over. The judge has ordered a return and report on this, and they might be able to make a huge step forward, which I doubt, because they still, one side, for them to move forward, this is not going to be like where you're playing war with cards, as a kid, you turn over the card at the same time and see who wins. The other side is still going to hold their cards close to the chest. They don't want to give up anything until they see, you flip your cards first, then I'll show you what I have. and so no one's going to give in. It might take the judge, requiring them to file a motion or a written thing or something to address this. But anyway, that's where it's at. It's crazy. It's crazy. And to end on fireworks was fantastic. It's a great way to kick off the weekend. By that being said, Donna, you are right. This is sad. The entire process with Maya, with Beata, with the family, with Jack, with Kyle, just everything that's involved. There's a family in the middle of this that went through hell. And is it the hospital's fault? Maybe. Is it? It's rough, and it's all being played out on national television right here, on YouTube, where everyone can see, and the medical records, every private detail is being blown up on the big screen and shared, and it's crazy. It's the system we have. It is crazy, but I will tell you, I am so grateful for you guys. You in chat, this entire group who was able to look at this really tough issue, to look at this and approach it in a respectful way, and be able to look at this and weigh the issues and the testimony and be able to communicate opinions and things like that without resorting to personal attacks and things like that. That's what makes this well worthwhile. And thank you so much for all of that. That being said, I think it's time for us to hit this button and play some outro music. Somebody asked, do I make my own music? I'm not that talented. I play the guitar, but not that well. So that was Christina. This is actually from YouTube's free little library. But so you can find this. It's part of the content that's available to creators on YouTube, royalty free. Anyway, thank you all. I want to say thank you so much to Rob at Lawn Lumber. It's been a pleasure getting to know both him and his community. And so many of you came over. Thank you so much for that. I owe him a massive thank you. Thank you. Tonight when you go home, please hug the people you love. Smile at someone. Make their day just a little bit better. And please stay safe till we go live again. For us, it will be tonight at 8 p.m. with our podcast. I know I'm probably going to see many of you over in Rob's chat as well. I'm going to redirect you over to Rob's chat now once this ends. So if you just sit there and hold tight, strap in, we'll make the jump together. I know he doesn't go live for a little while, but a lot of people like to talk in chat. I'm not sure if his chat's open yet. We'll have to watch for that. Anyway, at least you can go over, click the like button, and hit the notify button so you can be notified when he goes live. I think that's everything. You guys, it's been a fantastic week. I look forward to spending another week with you next week as this continues. It looks like we'll start about 8:15 on Monday, and that'll give us some time to sing happy birthday to everyone who had a birthday over the weekend or on Monday, which we do every day, and we'll go from there. Guys, have a good one. Stay safe. Be good to each other. We'll see you.